Villages. It's a retirement community.
Okay.
Yeah. Yeah.
I'll wait for your call. All right, you ready?
Yes.
I'm Troy Gump, Zoning Board Chairman, and I'd like to call this order to meeting. It is 7:05. I'd like to take roll from my left to right. We have Liz Ross, Cecil Zoning Officer, Solicitor Chris Voltz. To my far right, Ted Donald. And we have stenographer Kathy Landock. At this time, I'm looking for a motion to approve the minutes from February 17th, 2025.
I'll make that motion.
All in favor? Aye. 2-0.
Okay.
Whole business, I guess.
Yes. So before we proceed with Range Resources Application 2024-0015, Joe Flaherty is absent today, and he has indicated to me that he intends to recuse himself from this matter. So he will not be seated for the remainder of the hearing. With that, we are ready to proceed with Range Resources case. At our previous meeting, they presented one witness that was cross-examined by the township and other interested parties. The procedure for today will mostly be the same. Attorney Kimberly Brown will present her witnesses, and then they will be cross-examined by the township, Georgetown Estates, Dwight Ferguson, Clean Air Council, and then Bernard Matthews will not be here tonight, so he will not be cross-examining. We do request that attorneys not repeat questions that have already been asked, so we can move forward with this in a timely and efficient manner. We would like to get through Range Resources witnesses and presentation tonight. So with that, let's get started.
Mr. Volz, before we get started, if I may, Gretchen Moore on behalf of the township, I would like to make an oral presentation for a motion to dismiss this time based on mootness. As this board may know, on April 7th of this year, the Township Board of Supervisors passed a new ordinance, Ordinance 5 of 2025. That ordinance repealed and replaced Ordinance number 9 of 2024, which is currently being challenged here. And it, not only repealed and replaced it, but made some significant changes to portions of the ordinance that Range is challenging, in particular, Section 36, which is now Section 35, and it makes substantial changes to that section, as well as changes throughout. I wanted to put this on the record, as well as give you a copy of the new ordinance, which is, as I said, 5 of 2025. Kimberly? So at this point, we've already asked for this case to be dismissed on the basis of standing. We've asked this case to be dismissed on the basis of ripeness or lack of challenging anything in particular. Of course, we weren't able to present those motions, but at this point, we are now moving on behalf of mootness, because the particular ordinance that is being challenged is not even an ordinance that is in effect, and there have been substantial changes made to the very portions that are being challenged. So it really is the trifecta at this point. We have a lack of standing, we have a lack of ripeness, and a mootness argument. So we would ask this board to please consider that before proceeding with this challenge. Thank you.
Before I have any questions, I'd like to turn it over to Ms. Brown for a rebuttal or for a statement regarding this motion.
I'm happy to respond, Mr. Volz. My understanding is the issues relating to the motion to dismiss you have already determined were not to be heard at this time, but at the close of the presentation of evidence. With regard to the issue of mootness, the argument presented by counsel for the township is contrary to the state of Pennsylvania law, which has been the law of Pennsylvania for over a century. And that is that the repeal of an ordinance does not moot any challenges to that ordinance where it has been reenacted in substantially the same form. That quote is from the Pennsylvania Supreme Court decision in 2013 from Stuckley, and Stuckley cites I believe it's a 1919 decision from the Pennsylvania Supreme Court along the same lines. There also is another appellate court decision from the Pennsylvania Commonwealth Court stating that the enactment of a revised ordinance did not moot the challenge because the new ordinance did not substantially grant the applicant's requested relief. The challenge to the ordinance relates to the exclusivity of the ordinance, the fact that it precludes oil and gas development, and the new 2025 ordinance does not address any of those issues, particularly the setbacks that Range is challenging in its pending challenge. As a result of that, under Pennsylvania law, when laws are substantially reenacted by the repealing act itself, the proceedings may be continued and concluded under the new law. And so therefore, this is not a mootness argument under Pennsylvania law. And also, even if it was, the enactment of the ordinance should not moot the challenge because there are exceptions to the mootness doctrine, which would apply, particularly that this issue is capable of repetition while evading review, that there is an issue of public importance, and also it is detrimental to Range to have to proceed with a substantially new challenge that repeats the challenge it has already made to the 2024 ordinance in essentially the same form with respect to the 2025 ordinance. We have also prepared for presentation this evening an amendment to Range's challenge, which we have marked Exhibit 1.1. Exhibit 1, as you may recall, members of the board and Mr. Volz, was the 2024 ordinance. Exhibit 1.1, which we offer, is Range's amended challenge, which includes now a challenge to the 2025 ordinance. The same setback provisions that were identified before in 2024, as well as the setback provisions that are still existing in the 2025 ordinance, with one exception being that there is a slight subsection change to the 2025 ordinance because one of the subsections in the 2024 ordinance was removed. And so essentially, Range's challenge remains because the ordinance remains. And that's Pennsylvania law, and there isn't a basis or an argument which relates to this issue that has been cited by counsel for the township that would support this request for relief.
Okay.
Mr. Volz, we can cite the same case you cited, which is Stuckey, and I think you used the exact language, which is when, basically what Stuckey says, when you reenact an ordinance for purposes of getting around a substantive validity challenge, you don't make significant changes to it. That is not a mootness argument. Here, as you can see in the red line version of ordinance number 5-2025, there are significant changes to one of the subsections that they are challenging, which I think they recognize by the fact that now they are trying to amend their challenge to include the new ordinance. So they have challenged the old ordinance, they would amend it to have a challenge to the new ordinance as well, which I don't think is appropriate.
Mr. Volz, may I speak to this?
Of course.
On behalf of the stone marks, I'm joining in the motion. I'd like to direct the board's attention to Range's exhibit number, it's their appeal. So that was the first appeal. Okay, it's exhibit number 1, and the attachment, which is the second page of their appeal, identifies 2 provisions that they were challenging, ending in 5 and ending in 36. Attorney Moore has just provided the board with a copy of ordinance number 5-2025. Exhibit B, in the back of that ordinance, it's marked gigantically like that. Exhibit B is a redlined copy of ordinance 9-2024, showing every single change to ordinance number 9-2024, which created ordinance number 5-2025. And if the board goes through that, let's see, that's a double-sided copy. It would just be the third page from the end of Exhibit B. You'll see what was formerly 36, paragraph 36 of the ordinance, which was challenged by Range, now renumbered 35. And all of the language which is in red has been deleted, and all of the language which is in blue, which carries over to 2 pages and adds 1, 2, 3, 4, 5, 6 new paragraphs, are all of the changes in the new ordinance. So it's incredulous that an officer of the court would tell this board that this ordinance was reenacted without any changes. In fact, there's at least 6 paragraphs, and every other paragraph of this section was changed. So when you go back to Stuckey, that is the authority which says she's right that if in Stuckey it was kind of a ruse, because what the municipality did to avoid a challenge was repeal the old ordinance and then reenact it verbatim. That's not what happened here, as you can see, because the township has been very meticulous in letting the public and everyone else know of all of these substantial changes to the paragraph that was challenged. Now, Range, while denying that the changes were significant to warrant a new appeal, is now appealing the new changes. But the notice for this hearing tonight to the public does not include a challenge to Ordinance 5 of 2025. So even if the board felt that they could proceed to challenge a substantially revised ordinance as to paragraph 36, which did not conclude under Stuckey, there still wouldn't be notice to the public that now we have an entirely new ordinance with its changes being the subject of a public hearing. So I would like to add that as a basis for the motion to render this appeal moot and to dismiss it.
My question to the township and the objectors, I was unaware that the ordinance had been amended. It was not brought to our attention prior to tonight, or repealed and replaced. Are the setback requirements the same under the old ordinance as they are under the new ordinance?
So under section 36, which is now section 35 of the new ordinance, there are significant changes, as I said. The first is that oil and gas processing plants and compressor stations are allowed in the industrial district, subject to the setback set forth therein, which frankly is exactly how it's been in this township for the past 10 years. So there is no difference as it relates to compressor stations and processing plants. As it relates to other oil and gas facilities, there is those would be smaller facilities. There is a 2,500-foot setback, but it is now subject to the waiver provisions, which Range hasn't really acknowledged yet, which means that any property owners in that 2,500-foot setback area can choose to waive the 2,500-foot setback. So we have the larger compressor stations and processing facilities allowed in the industrial district, as they always were, subject to the setback set forth therein. Other facilities allowed with a 2,500-foot setback and a waiver provision process is now included in that particular section of the ordinance. There also is a section to section C1, which addresses pre-existing well pads, and there are some language changes in there. Again, I don't know what they are appealing, frankly. We haven't heard exactly what they are appealing, but to the extent they are appealing some inability in those pre-existing well pads to do something, there is now different language in subsection 3C1 that addresses that. Thank you.
Ms. Brown, do you have anything you would like to?
I do, as an officer of the court, I do have something to say, and I did not represent that there were no changes in the 2025 ordinance. I was merely referring to the standard that the Supreme Court has said when an ordinance is substantially reenacted, that if the challenge, the basis for the challenge is not addressed or has not been repealed, and not reinstated in a new ordinance, that the challenge can continue on. And an example of that is in the Weimer case that I mentioned, the Commonwealth Court decision in 2019, where landowners who operated a barn wedding venue pursued a challenge to an ordinance that had been passed. There was a subsequent ordinance that was passed that was found not to have mooted the landowner's land use appeal when they sought denial of the board's challenge to the zoning ordinance and refused to accept the proposed curative amendment. The ordinance, the secondary ordinance, did not address all of the issues that were pending in the earlier challenge, and as a result, both the Commonwealth Court and the Supreme Court found that the challenge could continue, even though there had been an attempt to repeal. The issue is very clearly laid out in Ranges Exhibit 1 and Exhibit 1.1. And if you go to Exhibit 1.1, you will see that with regard to the 2024 exhibit, this is on page 2 of the exhibit, members of the board and Mr. Solicitor, where the bulleted section is, it identifies the Ranges challenge. Again, this is an exclusionary zoning challenge. It relates to the fact that there are setbacks that preclude oil and gas development. It has always been Ranges challenge, and it's laid out in writing in black and white on our challenge that was Exhibit 1 already previously submitted to the board, as well as Exhibit 1.1, which spells out that the setbacks are the issue of Ranges challenge to the 2024 ordinance and now the 2025 ordinance. And interestingly, you did not hear anything from counsel for the township say that there were any changes to section 240-61.C5, because there have not been. Those setbacks are still in effect, as well as setbacks in a different form, but still exclusionary, in now what is known as 240-61.C35. The sum of this is that if there's a reenactment of an ordinance that doesn't address the challenge that is pending, the Supreme Court has said the challenge can continue, and the way that that continues procedurally is under the new law. That's what the court has said in Stuckley. And so that's what we're doing, exactly what we're doing, which is amending our challenge consistent with the guidance provided by the Pennsylvania Supreme Court to continue the old challenge under the new law. That's all we're doing. Exactly what the Supreme Court said we need to do.
Do you have a copy of the Stuckey case and the Weimer case on you?
May have one, it may be marked up though.
Thank you.
If I may, the last line says, thus the repeal of an ordinance does not necessarily move any challenges to that ordinance where it has been reenacted in substantially the same form. So our position is whether or not this is in the same form. That's the issue before the court. That's section 36, whether that is substantially in the same form as it was in Ordinance 9 of 2024.
Schultz, do you have a copy of both Stuckley and Weimer?
This is Stuckley.
I have a copy that is, it's got a few underlines.
Okay. I don't think that'll share too much of your thought process.
I don't think there's anything else that's on here.
Thank you. Motion to recess to executive session.
At this time, I'm making a motion, looking for a motion to have an executive session.
I'll second it.
We'll be back in a little bit.
I'd like to call the meeting back to order. Time 7:37.
Okay, the board has discussed the pending motion to dismiss, and what we have decided to do is we are going to let Range proceed with its case tonight. At the conclusion of tonight's proceedings, we're going to have the parties brief these issues raised with respect to whether the challenge is moot, and we would ask that briefs be submitted within 2 weeks of today, which is May 5th. And the board will issue a decision on the mootness issue at the next scheduled meeting. May 5th for the briefs. And with that, Range Resources can proceed.
Thank you, Mr. Volz. Members of the board, we would like to offer up Exhibit 2.1, which is the Cecil Township Ordinance Number 5-2025, as it was posted on Cecil Township's website.
For all the reasons I just presented, I would object to the inclusion of ordinance number 5-2025, in particular the fact that it was not properly advertised at this hearing tonight as a challenge to ordinance number 5-2025, and the fact that they're trying to bootstrap it into this existing hearing.
Right, and we came here without notice that they intended to proceed with an apparent challenge to ordinance 5-2025. So I would suggest that they be permitted to proceed with their challenge as to ordinance 9-2024, but not to proceed as to an ordinance for which there's been no public notice.
Okay, understood. At this time, those objections are overruled.
Mr. Volz, with regard to the exhibit binder that was used at the last time of the hearing, is that available for our witnesses to use? Okay.
I don't understand what you mean.
When we introduced exhibits with our witnesses at the last hearing, I believe that you took possession at our suggestion of the exhibit binder. And we would like, if it's possible, we would like to get those exhibits back so the witnesses can use those for purposes of examination today. It's just the original admitted exhibits. And we'll be adding 2.1.
I already put it in there.
Just requesting yours or all of us?
No, just this one.
We're adding for the record exhibits 1.1 and 2.1. Or may I say we're offering for purposes of a
Accepted,
ruling?
yes.
Thank you.
And the township objects to those.
Understood.
join in all the motions, can we just make a blanket statement that we would join in the township's motions unless we inform the commission otherwise? Or any objections, excuse me.
Okay. It will be presumed that all of the objectors join in the township's objections unless they state differently.
Excellent, thank you.
Praise calls Mark Lindbruder. Okay. Okay. You want to place under oath?
Sorry? He needs to be sworn in, yes.
Raise your right hand before me. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
Please state your full name and spell your last name for the record.
My name is Mark, and that's Mark with a K, Limbruner, Limbruner.
Where are you employed, Mr. Lindbruner?
I'm employed by Range Resources Appalachia, LLC.
How long have you worked for Range?
I've been employed with Range Resources since 2008.
What's your current role with Range?
My current role is I'm the Director of GIS Services.
What does GIS stand for?
GIS stands for Geographic Information Systems.
What are geographic information systems?
GIS systems are basically a tool combining CAD automated mapping combined with the ability to manage and analyze various databases and to store and analyze that data.
And what does GIS services do within Range?
GIS services, we basically function as the mapping department for Range Resources. We provide mapping to a number of different departments. We provide analysis, and we function as basically the mapping department for Range Resources.
How long have you been the director of Range's GIS services?
I've been the director of GIS services since 2020.
What are your responsibilities in that role?
My responsibilities are to oversee the GIS department. There's 4 of us in the department. I have 3 GIS analysts that work for me, and my job is to oversee their work, serve as a project manager, do quality control on their work, and also to perform some mapping and analysis projects on my own for my own clients.
Do you, in connection with your responsibilities, do you work with other Range departments?
Yes, I do. We work very closely with the geology department. We're actually part of the geology department. We work with the land department. We do work for senior management. We do work for surface land group, government affairs, and so forth.
Do you do any work with Range's regulatory department?
Yes, we do.
And what kind of work do you do for them?
We do work, various analysis, mapping of property setbacks, perform analysis for area reviews for submittal to the state prior to drillings.
Did you hold any other roles at Range prior to your current role?
Yes, I was the manager of GIS services when I was first employed there in 2008.
How did your work as manager for GIS services compare to your work now as director?
The work was basically the same. I oversaw the GIS department. Becoming director in 2020, it was really just a title change.
Did you work anywhere else before you joined Range?
Yes, prior to joining Range Resources, I worked for an internal subsidiary of Consol Energy. We managed the mapping and databases to manage the oil and gas wells and leases that were acquired prior to longwall mining.
Where did you work before that Consol subsidiary?
I spent 2 years with CNX Gas.
And what did you do while you worked for CNX Gas?
For CNX Gas, I was initially hired to launch their first mapping department. I was recruited to create the mapping department, develop standard operating procedures. This is when CNX Gas was drilling coal bed methane wells. And one of my jobs was to recruit, hire, train, and develop their mapping department.
Did you work anywhere before CNX?
Yes, before CNX, I spent 10 years approximately with Key Environmental Incorporated, which was an engineering firm in Carnegie, Pennsylvania.
What kind of work did you do while you worked for Key Environmental?
For Key Environmental, I was the coordinator of GIS and CAD services at Key Environmental. We took care of mapping of the projects for our clients. A number of the projects we worked on were either covered by state agencies, laws, or also federal programs, including RCRA and CERCLA projects.
You mentioned RCRA. Is that the Resource Conservation and Recovery Act?
Yes, it is.
And CERCLA, is that the Comprehensive Environmental Response Compensation and Liability Act?
Yes, it is.
What about before your work with CNX? Did you work anywhere else?
Before I was employed by CNX, before I worked for Key Environmental, I worked for Keystone Consultants Incorporated of Carnegie, Pennsylvania.
What kind of work did you do for Keystone Consultants?
Keystone Consultants at that time provided civil engineering and mapping services to clients in the oil and gas industry, utility industry, and at that time we were taking a number of their old hard copy maps of our clients and digitizing them and bringing them into and up to date with the modern GIS and CAD systems.
Were you employed before your work with Keystone Consultants?
Yes, I spent approximately 12 years with Mark Resources Corporation, which was an independent oil and gas company located here in Pittsburgh.
And what years approximately did you work for Mark Resources Corporation?
From 1982 until late 1993.
And what kind of work did you do while you were with that company?
I served as the senior draftsman and a geologic technician with Mark Resources.
And was Mark Resources your first job in your career as a GIS professional?
Yes. I joined Mark Resources Corporation immediately after graduating from Conley Technical Institute. I attended Conley Technical Institute to study drafting and design technology, and I specifically specialized in cartography and topographic drafting.
So with regard to your employment, is it fair to say that you have approximately 40 years of experience as a GIS professional, mostly in the oil and gas field?
This past February, I passed my 43rd anniversary of doing mapping and GIS work.
You mentioned you're studying with Conley Technical Institute. Did you graduate?
Yes, I did. I graduated with a certificate in drafting and design technology.
And have you, since graduating from Conley Technical Institute, obtained any other formal education?
Yes, I attended the Community College of Allegheny County. They have an advanced AutoCAD program for AutoCAD customization. I attended that in the early 90s. I've also continued, and I really got into that as the technology was moving from manual drafting into CAD and GIS. So I took those classes. I've also continued my education by attending various seminars, going to conferences, and just keeping up my skills as much as I can.
Ms. Limbrunner, do you hold any professional certifications?
Yes, I'm a certified GIS professional.
And what organization certified you?
The GIS Certification Institute issues that certification.
What is the GIS certification?
The GIS Certification Institute is a industry group which was formed by a number of different nonprofits within the GIS field. And what we did, or what they did, was create standards for GIS professionals, educational standards, training standards, ethical standards, and they certify GIS professionals.
What is the process like to become a certified GIS professional?
To become a GIS professional, there's a test you need to take. You need to submit a portfolio of your work, get letters of recommendation from your employer and previous employers, sign off on an ethics statement, and then you can become certified.
Is a GIS Certification Institute certificate recognized within the GIS industry?
Yes, I'd say it's it's the most widely recognized certification in the GIS field.
Aside from obtaining a certification yourself, have you had any other involvement with the GIS Certification Institute?
Yes, I served from approximately 2016 through 2020 on the board of the GIS Certification Institute.
What were your responsibilities as a member of the board?
We had a very active board at the GISCI because we were the only, we only had one paid employee that was executive director. The rest were all volunteers. So we would oversee the finance of the organization. We would oversee the creation of standards for our members. We worked with educational and psychometric professionals to develop our testing. And then we would also review any ethics complaints against any of the professionals.
Have you been involved in any other professional?
Yes, I was.
Have you been involved in any other professional organizations?
Yes, I was on the board of directors of the Geospatial Information and Technology Association.
Did you also serve as president of that organization?
Yes, I did. I was on that board from approximately 2013 through 2019, and I served as the board president from 2015 through 2018.
What is the Geospatial Information and Technology Association?
I'll use the initials GITA. GITA at the time was the premier geospatial organization, and we focused on providing educational experiences, conferences, newsletters to promote the best practices for GIS in the industries. And really we focused on infrastructure, telecom, electric, oil and gas, utilities, transmission. That was really the focus of our organization.
How did you get involved in that association?
I became involved with GITA. There were several of us local GIS professionals that wanted to create a local, or let's call it a regional conference, focused on GIS for oil and gas and energy development. So we wanted to get the approval and the assistance of GITA to help run and sponsor that conference.
Mr. Voltis and members of the board, at this point we offer Mr. Limbrunner as an expert in the field of geographic information systems and mapping.
Any objections?
I don't have an objection so long as the opinion questions directed to him are confined to mapping and GIS.
And I do have a question of whether a report was prepared for this evening or not.
There was no
Ms. Brown.
obligation to prepare a report.
Understood. Okay, we'll accept you as an expert, and we will proceed with your testimony.
Thank you.
Mr. Limbrunner, as part of your work as a GIS professional, have you been asked to analyze regulatory or zoning setbacks to show how they apply to a given area on a map?
Yes, I have.
Could you please pull up Exhibit 2 in your binder?
Okay, I'm there.
You recognize this document?
Yes, this is Cecil Township Ordinance 9-2024.
Could you turn to subsection C5B, which appears on the 8th page of the document?
C5B, I am there.
You see that it states the nearest edge of the well pad shall be located not less than 2,500 feet from any protected structure, not less than 5,000 feet from any school or hospital, and not less than 250 feet from the nearest property line.
Yes, I see that.
Could you turn to the 4th page of Exhibit 2, please?
I'm there.
You see the definition of protected structure towards the middle of the page?
I do.
For purposes of your analysis, did you assume that any occupied structure would qualify as a protected structure under this definition?
I do.
Could you please turn to subsection C36A3, which is on the 21st page of Exhibit 2? On that page, you'll see 36 in parentheses and the title Oil and Gas Development Facilities.
C36, what's subsection?
A3.
I'm there.
You see the 2,500, 5,000, and 200-foot setbacks for oil and gas development facilities?
Yes, I do.
Mr. Limbrunner, please turn to Exhibit 2.1.
There?
You recognize this document?
Yes, I do. It's Cecil Township Ordinance 5-2025.
Is it your understanding that Cecil Township has enacted Cecil Township Ordinance 5-2025, which repealed Ordinance number 9-2024?
Yes, I do.
Have you reviewed the setbacks for protected structures, schools, and hospitals, and property lines in Ordinance number 5-2025 that replaced the Ordinance number 9-2024 setbacks you just testified about?
Yes, I have.
For purposes of your analysis and application of the setbacks in the two ordinances, are there any differences in the setbacks that would impact your analysis?
There were no changes in setbacks that would have altered my analysis.
Is there a generally accepted process or methodology that GIS professionals such as yourself follow when they want to show the application of setbacks like those in Exhibits 2 and 2.1 on a map?
Yes, you would, within your GIS software, you would do the analysis via creating buffers.
And in preparation for your testimony today, were you asked to prepare maps showing how the ordinance setbacks you just identified apply to a map of Cecil Township using that generally accepted methodology?
Yes.
Could you please turn to Exhibit 10?
Okay, I'm there.
What, in general, is Exhibit 10?
Exhibit 10 shows an aerial photograph of Cecil Township, and it shows the borders of Cecil Township, and it shows the Washington-Allegheny County line.
And you're referring to specifically Figure 1?
Figure 1, yes.
And in general, the entire composition of Exhibit 10, what is it generally?
It's an analysis of the buffers and setbacks detailed in the township's ordinance.
Okay. So did you use a particular type of software to generate the maps that are reflected in Exhibit 10?
The software that I utilized for this analysis was ArcGIS Pro, which is published by Esri, which is ESRI.
Have you regularly worked with ArcGIS Pro in your roles as manager and then director of GIS services at Range?
Yes, I've used that software for many years.
Do you know if ArcGIS Pro is a reliable software for accurately plotting locations on a map and measuring distances between points on a map?
Yes.
And how do you know that, sir?
From time to time, we not only do the mapping digitally in the computer, but we have to go out, we have to check well locations, property corners, property lines. So a number of times our work is being field checked by surveyors, and we've never come up with any significant discrepancies that may have been caused by the software.
Is ArcGIS Pro generally recognized in the field of geographic information systems as a reliable and accurate software for use in preparing mapping that depicts setbacks for use by companies seeking to comply with regulatory and zoning setbacks?
Yes, it is.
Let's talk about the steps that you took to prepare your maps. Could you turn to Figure 1 of Exhibit 10?
Okay.
What does Figure 1 depict?
Okay. Figure 1, as I mentioned a little bit earlier, is an aerial photograph of Cecil Township. It shows the Cecil Township boundary, and it shows the Washington-Allegheny County line.
And for purposes of the record, what color is the county boundary?
The Allegheny County, Washington County line is red.
And is that part of the Cecil Township boundary as well?
Yes, it is. That's where Cecil Township abuts Allegheny County.
And how is the rest of Cecil Township's boundary depicted on the map?
There's a blue boundary which shows Cecil Township boundary to the north, to the west, to the south, and to the southeast.
What are the steps that you took to create Figure 1?
To create this map, we obtained our aerial photography, imported it into ArcGIS, and then we imported the feature classes or the shape files which comprise the county boundary and the township boundary.
The steps that you just identified, are those consistent with the generally accepted methodology that a GIS professional would apply to map the application of zoning setbacks?
Yes.
Where did you obtain the base map?
The aerial photograph was provided to Range Resources via Thrasher Engineering.
And what is Thrasher Engineering?
Thrasher Engineering is a civil engineering firm located in Canonsburg. They provide aerial photography to a number of different clients, and one of them is Range Resources Appalachia.
Would it be standard practice for a GIS professional such as yourself to use aerial photographs from a company like Thrasher Engineering as a base map when mapping zoning or regulatory setbacks?
Yes, it would be.
How recently was the aerial photograph you used taken?
This photograph was taken in the late winter or early spring of 2023.
And does the aerial photograph you used fairly and accurately represent Cecil Township as viewed from above?
Yes, it does.
Where did you obtain the data for the township and county borders that are depicted on Figure 1?
The county and township borders were obtained from the POSDA database. I downloaded that and brought that into my mapping system.
You mentioned POSDA. Is that the Pennsylvania Spatial Data Access Database?
Yes, it is.
And you may have mentioned it already. maintains that database?
That database is basically the state of Pennsylvania's repository of GIS data that is available publicly. And so it's the state's official download site for data. And in addition, the site is actually maintained by the Pennsylvania State University.
Is the Pennsylvania Spatial Data Access Database generally accepted in the GIS field as a reliable source for mapping municipal and county boundaries?
Yes, it is.
Let's turn to Figure 2 of Exhibit 10.
Down there.
How does Figure 2 compare to Figure 1?
As we move on to Figure 2, I have now added the existing range resources Appalachia well pads, the Cecil Township occupied buildings, schools located in Cecil Township, and the Cecil Township tax parcels.
How did you identify the tax parcels that are depicted in Figure 2?
The tax parcels were provided to us by the Washington County GIS department. They have a download site where the public or professionals can go on to download the tax parcels for the entire county.
And why did you add tax parcels to this map?
The tax parcels serve as a good reference for where properties are within Cecil Township.
By mentioning properties, do you mean the lines of the properties?
Yes.
In your experience, is it generally accepted in the GIS field to use tax parcels as a proxy for property lines when mapping the application of zoning setbacks from property lines?
Yes, it is.
How did you determine the location of the schools that are reflected on Figure 2 of Exhibit?
For schools, again, I went to the state database, to PASDA, downloaded the schools, brought them into my mapping system, and then I confirmed their location against the aerial photograph, making sure that the school locations were the same as school buildings I could see in the aerial photograph. And then I double-checked that against the Cannon-McMillan School District website to make sure I had the proper address and locations for the schools.
And was there any further checking against the aerial photograph that you obtained from Thrasher?
Yeah, I made sure that those school locations were on the photograph.
How did you determine the location of ranges well pads that are depicted on Figure 2?
Those were brought into the mapping system via our internal databases, but those same locations are available publicly via state databases. They're all publicly permitted, or all the sites have been permitted through the state of Pennsylvania, so they're available on databases, publicly available databases.
Turning to the structures, how did you determine the location of occupied structures that are reflected on the map?
For occupied structures, again, I went to the Washington County GIS site, downloaded all the building footprints. Washington County makes those available also to the public. I brought those into the mapping system. Washington County also provides 911 address locations for all the occupied structures within Washington County. So then I compared the two. I compared all the building footprints against the 911 locations, and then mainly just kept the 911 address locations and kept those as the occupied structures.
Did you do any cross-referencing with the aerial photograph?
Yeah, I zoomed around in the map, made a very detailed examination of it to make sure that the county had not missed any properties. Occasionally, there's some buildings that might be missed or were located in the wrong position, and everything seemed to work out fairly closely.
Are the sources that you use for the tax parcels, occupied structures, schools, and existing range well paths generally accepted in the field of GIS for determining accurate placement of those items in a map to be used for regulatory and zoning compliance?
Yes.
Let's turn to Figure 3. What does this show?
Figure 3 shows all the same items that were on Figure 2, but at this point now, I've added areas that are beyond the 250-foot setback for the larger properties.
And how are those setbacks depicted on your figure 3?
Areas that are beyond 250 feet from the property lines are highlighted in green.
How did you create and apply this layer of the map?
For this, the process that you would take within the GIS is you take all of the parcels and then you do a negative 250-foot buffer, and you clip out those areas, and then the remaining areas, which are green, are what remain on your map.
And this process that you just described, is that still using the ArcGIS Pro software?
Yes, that was all done within ArcGIS Pro.
Is the process that you described consistent with the generally accepted GIS methodology you previously described?
Yes, it is.
So to be clear, are the green areas depicted on figure 3 on the map outside of Cecil Township Ordinance 9-2024's 250-foot setback from property lines?
Yes, they are.
And are they also outside of the 2025 ordinance 250-foot setback from property lines?
Yes.
Let's turn to the next page, figure 4 of Exhibit 10.
There.
What does this map show?
Figure 4 shows all the same items that were illustrated in Figure 3, but at this point, I've now added the 5,000-foot school setback, which are shown as blue circles around each school.
As you create and apply the 5,000-foot setbacks from the school, did you use the same process as you did for the 250-foot setbacks?
Yes, we use the buffering tools within ArcGIS Pro, only this time we're doing a 5,000-foot positive buffer around each school building.
Is it a correct interpretation of your map that the Connor Samuel well pad is within the 5,000-foot setback from one of the schools plotted on your map?
Yes, it falls within one of the blue areas.
Let's turn to figure 5 exhibit 10. What does this map show?
Figure 5 includes all the items that were shown on Figure 4, but at this point now I've added 2,500-foot buffer around each occupied structure within Cecil Township.
And how is that buffer depicted on your map?
That buffer is depicted as pink areas.
As you create and apply this layer, did you use the same process as you did for the other 2 setbacks?
Yes, I took each occupied structure and had the software buffer 2,500 feet from each building, and then the result is the pink area shown on the map.
And when you said building, are you referring to the occupied structures?
Yes, the occupied structures.
Is this the final layer that you applied to your map?
Yes, it was.
Does figure 5 fairly and accurately depict Cecil Township and the application of the ordinance setbacks you identified in exhibits 2 and 2.1?
Yes.
Figures 1 through 5 fairly and accurately depict Cecil Township and the information reflected in the legends for each of those figures.
Yes, it does.
To confirm, are the steps that you took to generate figures 1 through 5 consistent with the generally accepted methodology a GIS professional would follow to show the application of zoning or regulatory setbacks to a given area of a map?
Yes, they are.
Based on your description of these maps, is it an accurate interpretation to say that the areas hypothetically available for oil and gas development under the setbacks would have to be 1, outside of the pink shaded area, 2, outside of the blue shaded area, and 3, within a green shaded area?
That's correct.
Are there any such areas on the map?
There is no such area on these maps within Cecil Township.
So you did not include hospitals in any of your maps. Why not?
The hospitals would have been redundant just based on the 2,500-foot occupied structures buffer. Adding hospitals would not have resulted in any areas, any further areas where drilling would be possible.
So it looks like, if you take a look at the map closely, figure 5 specifically, that there may be a space directly north of the Augustine pad and another space to the northwest of the Schultz pad that are not shaded. Are those areas available for oil and gas development given the ordinance's setbacks?
Those areas, even though they fall outside of the blue and the pink buffers, they are not within a green area. So they fail due to the 250-foot setback buffer from property lines. So no, you could not locate a well pad in those areas.
Mr. Limburger, you testified earlier about data that you used to prepare the map shown in Exhibit 10. Were you asked to compile the data that you used to determine the placement of the Cecil Township and county lines, tax parcels, occupied structures, schools, ranges, well pads, and the reach of the applicable setbacks on the Exhibit 10 maps that you created?
Yes,
And did you in fact compile that data?
yes, I did.
Mr. Limburger, you have in front of you a package with a thumb drive marked as Exhibit 11. Could you hold it up, please? Have you reviewed the contents of Exhibit 11?
Yes, I have.
Does Exhibit 11 contain the data that you compiled to prepare the maps identified as Exhibit 10?
Yes, they have.
I'd like to note for the record that Exhibit 11 will be provided to the board and that copies are being provided to council. The exhibit binders contain a placeholder because of the content of the thumb drive. Mr. Limburger, do you have an opinion to a reasonable degree of certainty in the field of geographic information systems regarding whether there is any location in Cecil Township that could be used for oil and gas development based on an application of the setbacks in either ordinance number 9-2024 or ordinance number 5-2025?
Based on my analysis of the setbacks, there is no location in Cecil Township that could be used to locate a gas or oil well pad.
We'd offer exhibits 10 and 11 into the record.
Any objections?
Not to Exhibit 10, but to Exhibit 11, due to the fact we just received it tonight. Obviously, have no way of looking at it this evening.
Correct. We'll admit it into evidence. No weight to it just yet, though.
I have no further questions for this witness.
Okay, Ms. Moore, do you have some cross-examining questions?
Thank you, Mr. Bolts. Limburger?
Limbrunner.
Limburger.
Yes.
Mr. Limbrunner, what did you understand the scope of your assignment to be for tonight?
My assignment was to explain my analysis of the buffers and setbacks to create the exhibit for tonight.
What did you understand the scope of your assignment for this hearing to be, the preparation for this hearing, not just tonight?
To explain the steps that I took to make that map.
Were you asked to inquire into the ability of Range to erect a new well pad anywhere in Cecil Township? Is that part of the scope of your assignment?
No, my analysis was to see if anyone could locate a pad in Cecil Township based on the buffers and setbacks.
Were you asked to inquire into the ability of Range, or anyone for that matter, to erect any other oil and gas facilities in Cecil Township?
No, my analysis was completely based on well pads, on the ability to locate well pads.
So your scope was limited to siting of well pads, correct?
Correct.
Were you asked to assess whether Range's current well pads, right? So I think we saw on Exhibit 11, you have the 5 stars on there, right? Those are 5 existing Range well pads, correct?
That is correct.
Okay. Were you asked to assess whether Range's current well pads were impacted by ordinance number 9 of 2024?
No, I was not.
Okay. Were you asked to assess whether Range's current well pads were impacted by ordinance number 5 of 2025?
No, I was not.
And were you asked to assess whether Range can or cannot access oil and gas subsurface anywhere in Cecil Township?
Could you rephrase that question, please?
Were you asked to assess whether Range could access oil and gas subsurface rights anywhere in Cecil Township? Was that part of your assignment?
No, it was not. I was exclusively working on the analysis of the buffers detailed in the ordinance.
Now, Mr. Limburner, you testified that you reviewed ordinance number 9 of 2024, correct?
Yes.
And you said you actually also reviewed ordinance number 5 of 2025, correct?
I reviewed the sections related to the setbacks and the buffers.
You didn't review the entirety of ordinance 5 of 2025?
No, I did not.
Okay. Now, when you were reviewing ordinance 9 of 2024 and the portions you reviewed of ordinance number 5 of 2025, you saw section 5C of the ordinance, correct, related to waivers. Did you see that section?
No, I did not review waivers.
All right, let's take a look at that.
You,
So under
Would you like me to go?
ordinance 9 of 2024,
okay, I'm there.
and your counsel had pointed you to section 5, I think she said it was 8 pages in.
Okay, yeah.
You were previously looking at section 5B, which talks about the setbacks.
That is correct.
Okay, and then if we go on to section 5C, see that section on the next page?
Yes, I do.
Okay. In the event that an owner or occupant of a protected structure authorizes drilling activities upon his or her property, such owners or occupants may authorize the waiver of subsection 5B. Do you see that?
Yes.
Okay. And then it goes on, and I'm not going to read all of these, but there's C1, C2, C2A, C3, C5, which probably should have been C4. Do you see all of those waiver sections?
Yes, I do.
Okay. Now, as part of your analysis, did you consider whether or what waivers Range may need to place a well pad in any area?
No, I did not analyze. I was not asked to analyze the waivers.
Are you aware, so as part of your assignment, did Range tell you that they tried to obtain waivers from anybody in Cecil Township?
I'm not aware of that at all.
So you wouldn't know how many waivers Range would need anywhere on the map that you showed us to be able to site a well pad in any area.
It would be quite a task to analyze something like that individually.
Okay, quite a task because Range doesn't actually have a well pad that they're currently making any application for, correct?
Not that I'm aware of.
Okay, so it would be a task because it would be rather hypothetical, right?
Correct. You would be looking for creating hypothetical waivers to a hypothetical pad.
Right. You don't know if they could get a handful of waivers to place a well pad somewhere. You don't know whether they need 100 waivers to place a well pad. You just don't know.
Yeah, I would have no way of knowing that.
Now, as part of your mapping assignment, Range didn't inform you about any geological studies that they are currently undertaking to site a new well pad in Cecil Township, did they?
No.
And Range, as part of your assignment, didn't inform you that it applied for any DEP permitting for any new well pad in Cecil Township, correct?
I am unaware of that.
And as part of your assignment, Range didn't inform you about any new leases that they secured with property owners for a proposed new well pad in Cecil Township.
I am unaware of that.
And as part of your assignment, Range didn't inform you about the establishment of any new drilling units in Cecil Township for which a new well pad would be needed.
That's correct. I'm unaware of any new units being formed.
Now, again, going back to your map, Exhibit 11, we saw there are 5 Range well pads in Cecil Township, right?
Yes.
You already pointed those out, right?
Yes.
Okay. Now, does Range have any well pads sited outside of Cecil Township that extend under the surface into Cecil Township so that Range is accessing oil and gas underneath Cecil Township from a well pad that's sited outside of Cecil Township? Are you aware whether that's the case?
I am unaware if Range currently has any laterals extending under Cecil Township from outside of the township.
Did Range provide you with that Range didn't provide you with that information, is that right?
I was not asked to analyze that.
Okay. Did you ask them to analyze that? Did you ask them, hey, maybe we want to look at whether laterals are extending into Cecil Township from outside of Cecil Township?
No, the entire project here was just to analyze the occupied structures and the buffers from the schools, occupied structures, and the property lines.
You would agree with me that in unconventional drilling, you drill down and then you drill horizontally, correct?
That is what we do.
And those horizontal laterals, I think you called them, can extend pretty far, a couple miles.
In some cases they do.
Okay. But again, that wasn't part of your assignment.
That is correct.
As part of your assignment, did you calculate how much of the subsurface oil and gas under Cecil Township Range is accessing through its existing well pads in Cecil Township?
I did no such calculation.
You didn't go through that exercise. You did not go through that exercise.
No, yes, I didn't. Could rephrase the question, please, so I can give a proper answer.
You did not go through that exercise, correct?
I did not go through that exercise.
Okay, great. And don't you think that would be an important exercise to undertake if you are claiming that this ordinance is exclusionary?
From the analysis of the setbacks and the buffers, that is all that I was asked to analyze and render an opinion on.
Okay, thank you.
Mr. Lindbruder, my name is Dwight Ferguson. Your expertise in mapping and analysis does not include the feasibility of mining operations, isn't that correct?
That's correct.
And you have no associated education about mining engineering or to determine the feasibility of mining operations.
I am not a mining engineer.
It also does not include leasing.
That is correct. I'm not a landman.
And it doesn't include the economic analyses of oil and gas development.
That is correct. I'm not a petroleum engineer.
In your education, you have a certificate in drafting and design technology from Connolly Tech Institute. And was that an 18-month program?
There's a two-year
program?
program. Yes.
And then did you get a certificate or an associate degree from the Community College of Allegheny County?
I attended those classes for the AutoCAD program.
Did you get a certificate or an associate's degree from the Community College of Allegheny County?
No, just took the classes as part of my continuing education.
As Attorney Moore indicated, the exhibits number 10, none of them show the reach of existing horizontal drilling. Isn't that right?
That is correct because the exhibit only shows buffers and setbacks.
Okay. So if there are areas of Cecil Township that that can't be drilled, that is, for which oil and gas extraction could not occur, you certainly aren't. You certainly wouldn't be looking to horizontally drill areas that are already horizontally drilled. Is it not your understanding?
Could I have that back, please?
Yeah, that was a bad question. Oh, were you asking, or are you asking?
That was me.
All right, thank you. All right, so when you shade in the entire municipality of Cecil Township as there, including no area where new drilling could occur, you did not take into account areas of Cecil Township which are already covered by horizontal drilling, either from within or from without Cecil Township.
That's correct. I did no analysis. Excuse me. I did no analysis on lateral well locations.
And so in order for the board to determine whether or not Cecil Township is being fair and possibly excluding oil and gas extraction, wouldn't it be important for them to know whether or not there's any oil and gas to be excluded that isn't already accessed?
As far as the ordinance and my analysis of it, again, I have to repeat, it just pertains to setbacks and buffers in relation to the siting of new oil and gas well
Okay.
pads.
So understood. You had a limited responsibility here. You weren't here to cover every single aspect of drilling in Cecil Township. You were just mapping out the restrictions imposed by the zoning ordinance. Is that right?
That is correct.
Okay. But you would agree that in order to know whether or not there was the kind of exclusion that Range is asserting, you'd need to know how much of the township they're already accessing, either from within or without Cecil Township, to know whether or not there's a reasonable amount of access to oil and gas. And that they can't just rely on your mapping. Is that right?
Objection.
Sustained. I think you're asking for a
Well, she
legal
didn't articulate
conclusion.
an objection.
Sustained.
What's being sustained? Just the word objection? What's the objection? Besides, and the rules of civil procedure don't apply, as you've reminded the board earlier.
Like a response, Mr. Volz?
Please.
My objection is multiple. One is that it calls for a legal conclusion. It also is irrelevant, and it was compound. There were multiple questions that were asked.
Sustained. I agree. It was calling for a legal conclusion.
Now, so limiting the scope of your responsibility here, it was to accurately reflect in Exhibit 10 the effect of the zoning ordinance prohibitions on drilling in Cecil Township. Is that fair?
No. The analysis of the buffers illustrates where well pads theoretically could be located, and the buffers indicate you cannot locate any new well pads in Cecil Township.
Okay. And those conclusions, however, were based upon the limited sections of the zoning ordinance that you were asked to consider.
Yes.
Okay. And it wasn't until you were cross-examined by legal counsel for the township that you now are aware that the ordinance allows waivers. So if you go back to Section 5, Exhibit 2, and we look at, let's go to B, which is the provision that you studied. There is a 2,500 feet setback from protected structures. There's a 5,000 feet setback from a school or hospital, and a 250 feet setback from the nearest property line. That's what you studied, right?
That is correct.
Okay. But if we go to C, it says that in the event that an owner or occupant of a protected structure authorizes drilling activities upon his or her property, such owners or occupants may authorize the waiver of subsection B. So that would at least be the 2,500 square foot protected structure, right?
Objection. provision has been asked on cross-examination.
Overruled, you can answer.
Could you rephrase the question,
Yeah,
counsel?
so C, because it talks about an owner or occupant giving a waiver relating to the setback from a protected structure, if the waiver was granted, that would eliminate the 2,500-foot setback. Is that right?
The way that I would read this, again, an analysis of pad locations and the buffers, if, as I answered Ms. Moore, is if we were to look at any theoretical well location and then try to calculate all the various waivers which would be needed to locate that, it would be a fairly large analysis job to be able to analyze all those different waivers that would be needed.
Well, sure. Plus, you don't have any of that information
That is correct.
because they don't exist. Waivers don't exist as of today.
As far as I know, no waivers have been requested.
So if we look at Figure 5, the areas that are shaded in pink, this is under the assumption, this is under the assumption that every single person who signed a lease with Range Resources to allow oil and gas development on their property would not sign a waiver. In which case you would end up with this entirely pink map that you have, right? That's what you didn't take into consideration a waiver, so you in creating this figure number 5, everything turned pink because you didn't take into consideration that property owners could grant waivers, right?
Objection. There were at least 3 questions there. I'm not sure which one is currently pending.
I was just trying to make it clear. Did you understand the question?
Before, the objection is overruled to the extent you understand the question.
Okay. Could counsel rephrase that question, please?
You're shading the entire township of Cecil pink. Simply, in retrospect, it assumed that there were no waivers on any property in the entire municipality.
Because the ordinance is
Well, that's a yes or no.
Objection. The witness is allowed to answer a question.
That should,
Cross-examine.
we'll allow him to finish his question. If he doesn't answer it, you can ask him another one.
The ordinance is written that there is a 2,500-foot buffer from each occupied structure. That ordinance is there. There's no way to calculate what waiver might be needed or might be received. That's my answer. So the analysis of the 2,500-foot occupied structure setback specifically shows what is written in the ordinance.
With the exclusion of the waiver provision. We can agree that if everybody had a lease and everybody granted a waiver, there'd be no pink on here.
Objection.
I'd have no
Wait,
way.
She has an objection. We'd like to know what it is.
Lacks foundation.
The objection's overruled. You can answer the question.
Could you rephrase the
If
question?
everybody in Cecil Township gave Range Resources a lease and everybody gave Range Resources a waiver, there'd be no pink.
There would be no way, again, there would be no way to calculate that because not everyone controlling an occupied structure is going to be a lessor to Range Resources Corporation. There's going to be individuals that do not have a lease. They have surface rights and they're at that location and they may or may not sign a waiver. That is total speculation that any particular landowner would sign a waiver.
I was asking you a hypothetical question. So if you assume in the hypothetical that every person in the township had a lease with Range and every person signed a waiver, then there'd be no pink.
I don't believe my position in my analysis is to answer theoretical questions.
Okay. So when you created these figures, you used aerial mapping, right?
That is correct.
And that's essentially an overhead photograph of Cecil Township, is that right?
That is correct.
Okay. And what's the scale of the aerial map that you relied upon?
The resolution of that map is, each pixel is 10 centimeters.
Do you understand the difference between scale and resolution?
Scale is the size of a map, and how many inches would equals how
And I
many
asked you
feet on
about
the ground.
scale, not pixels.
That's,
What's the scale of the aerial map that you relied upon?
the resolution is.
Nope, not the resolution, the scale. We're not buying a TV here. We want to know what the scale of the map was. Maps have scales.
I could make this map, depending how big I want to blow it up, I could make it 1 inch equals a mile. I could make it 1 inch equals 500 feet. I could make it 1 inch equals 50 feet. Scale is irrelevant when you're talking about aerial photography on an exhibit like this.
And the aerial map is actually a photograph of something that's three-dimensional, isn't it?
Yes, the world is three-dimensional.
Okay. But the county and township border map that you relied upon is two-dimensional, isn't it?
Yes.
Okay. What was the scale of that map?
Again, the
It
scales.
didn't have pixels, so we shouldn't be confused with that. What was the scale of that
The
map?
scales are irrelevant. You bring in the data into the ArcGIS Pro, and what you do is you manipulate it, and you're really talking about, I'm talking about scale or resolution on the aerial photograph, but what you're mentioning, Consul, is how that data works together. It all gets brought together. You're going to bring that into the system, and you're going to tell it what map projection you're going to use. For our work at Range Resources, we project everything in UTM Zone 17, NAD, North American Datum, 1983. That's the projection that we use. We bring in all the data to it, and then we can scale it up or down depending on what we need to make our map presentation.
Okay. But the documents from that you input into your system, and we didn't even mention the Washington County GIS Department tax parcel maps, they're all at different scales, but somehow you need to have them all be at the same scale, otherwise you'd have a horribly inaccurate document.
Now, let me correct you. Whenever you bring in data into a GIS system, the way it works, it's basically in its real-world coordinates. And as you bring it into the system, as long as you have everything in the same projection, in the same coordinate system, it's going to display properly. Washington County provides their data, POSDA provides their data, we bring it into ArcGIS Pro, we reproject it into NAD 1983, UTM 17 North, and then we create our map.
Okay. When we go to, I ask you to turn to figure 3. Well, let's go to figure 4. So this is before we get to the waivable 2,500-foot setback. What percentage of Cecil Township is shown in green there?
I have no idea. Did no analysis of the green areas.
It's not even on the thumb drive that you gave us? That information isn't even on here?
Somebody could, if they take that system, they could easily do an analysis and a calculation of what areas are left in green.
Okay. But you would agree that as we look at figure 4, the areas in green are a substantial portion of Cecil Township, aren't they?
No, I would disagree with that.
But you haven't quantified it.
No, it's
Okay.
Visually looking at the map, the green are islands, islands of potentially drillable area, and no, I wouldn't say it's a substantial area.
Okay, that's all the questions I have. Thank you.
Anybody else from the objectors?
Yes, I have a few questions, Your Honor.
Not Your Honor.
Hi, Mr. Wimbrunner. Oh, wait, excuse me, sorry, did I?
I appreciate it, but no.
I might have misunderstood your prompt. Should I continue? No.
Yes.
Okay. Hi, Mr. Limbrunner. Thank you for being here. I want to ask you a few questions about the scope of your assignment. You compiled information from a few different sources. Were you instructed to use information from any particular source?
No.
It was just, oh, go ahead.
Go ahead.
I was just going to clarify it was your professional judgment and discretion as the mapper to choose the.
Yeah, as being the GIS director and with my experience, I was asked to analyze this, and I know innately where to go to obtain the latest and most up-to-date data.
Thank you. Were you asked to determine whether a smaller setback would have accommodated any new development of any kind?
No, I was not asked to do that analysis. I was asked to analyze the ordinance only.
Okay. And so then, in addition to not analyzing whether the length of the setback were shortened, you also weren't asked then to see if certain categories of buildings were removed from the ordinance, whether that would allow development in certain areas?
No, I just looked at occupied structures again.
Thank you. This was a purely desktop exercise, correct?
Yes.
You didn't go out, boots on the ground, and check on any information other than from the sources that you identified in your direct examination?
That is correct.
Okay. To look at some of those categories, I want to start with property lines. You said that you used tax parcels from the Washington County GIS office. Is that correct?
That is correct.
And did you determine whether one or more or two or more of those tax parcels had the same ownership? Contiguous tax parcels, excuse me.
I did not look at individual tax parcel ownership.
Okay. I also wanted to ask kind of where the tax parcels and the county boundaries interact. For your assignment, you assumed that where the county boundary was, that also represented a property line, correct?
Property boundaries, along the county, it may almost create a ragged edge because there's different assessments, which a parcel might be assessed in Allegheny, it might be assessed in Cecil. So I took all the parcels and clipped them to the county and the township boundary because I didn't want to look at any parcels or any properties outside of Cecil Township. I was looking exclusively within Cecil Township.
Understood. Maybe if I could ask a more pointed question. I believe Ranges Council asked you about the little area directly north of the Augustine George well pad, and I'm looking at Figure 5 of your exhibit. So to take this parcel where that little area is as an example, there would not be green within 250 feet to the southwest of the Red County line there, correct?
Yes, there's no green there because basically the county line is 250 feet or closer to those property lines. In addition, that parcel, I believe, is the turnpike, and so no development could occur on it.
Okay, but that would apply throughout your map, correct? That there is a 250-foot setback from the county line, regardless of whether or not one person owns property on both sides of that line.
Did you rephrase that?
Yes. Throughout your entire map, your green islands here are drawn 250 feet from a county line or a township line, for example, even if the person on the other side of that line owns property on both sides?
No, those green, let's call them the green islands, as you called them, those are drawn 250 feet inside any parcel that's completely located within Cecil Township.
Only the parcels located completely within Cecil Township.
Yes.
Okay. Now, when you define parcel, are you just defining it in the exact same way that the tax parcel maps define it?
That was my source I used for the analysis.
Which obviously, if our tax parcel maps are only from the county, they are not going to be tracking whether or not ownership of that property extends to the other side, correct?
Some cases they do, and some cases they don't. As I said, it's.
You don't know whether they do here.
No, I don't.
Okay. What do you understand the purpose of the tax parcel maps to be?
The tax parcels serve as a guide for where the property lines are. Obviously, the property lines in the real world don't fall exactly where the county has them mapped. That's why in oil and gas development or any engineering, you would go out and you would survey your property corners near wherever your development is going to be.
Okay. And you would agree with me that the purpose of these tax parcel maps is for the jurisdiction that maintains them to keep track of whether or not taxes have been paid on any particular piece of property.
That's correct. They're kept for tax purposes.
And if I were to own property that extended over the township line, I would presumably have a parcel in the Union Township, or excuse me, in the Cecil Township mapping, as well as in the neighboring townships, correct?
Generally, the townships, generally the parcels are split along township lines, but not always.
Okay. I noticed, turning to Exhibit 1 or Exhibit 2.1, I believe Ranges Council asked you about both. Needless to say, in looking at the provision of the ordinance that includes the setback requirement, you notice there was also language in there about lines having to do with subdivisions that have been approved or disapproved.
Could you cite me that section?
Yes, I'm looking at Exhibit 2.1, for example, Section 5B. I think it's actually C5B.
Okay, I'm there at C5B.
And do you see after 250 feet from the nearest property line, there's a few sentences there that discuss how you treat property lines for subdivisions or master plans? Do
Yes,
you see
I
that
see
language?
that. I see that section.
And then it goes on to say, looking at the last sentence of that paragraph, that there is this, there is a different setback of 1,000 feet from the nearest lot line of the approved subdivision or plan. My question is, do you know whether any of the boundaries that are part of this Cecil tax parcel layer are have to do with approved subdivisions?
I have no idea.
Okay, that wasn't part of your analysis?
No, it was not.
Okay. Moving then to the layer of Cecil occupied buildings, I had in my notes that maybe you consulted two different shape files to create this, the red polygons, I guess you could call them.
Yes.
And one of those was Well, I apologize. I think they maybe both came from the Washington County GIS office. Is that correct?
That is correct.
The first one you consulted, let me just ask you, what were those two shape files?
The shape files consulted to create the occupied buildings in Cecil are the building footprints from Washington County. Building footprints from Washington County, include your house, garage, church, chicken coop, shed, barn. Now, all of those I don't consider occupied structures. For the purpose of analyzing the ordinance, what I also did, I compared all those building footprints to the 911 locations that are located by Washington County, same, the GIS department. And I eliminated any of the building footprints that did not intersect a 911 location.
Okay, and so it sounds like maybe the more important of the two is the 911 locations.
I consider that to be, because those are the occupied structures where residents are.
Okay, and what is the purpose? Well, let me first ask you, do you know who collects the information that goes into that shape file?
Washington County would do that.
Okay, and do you know the purpose for which they are collecting it?
They're collecting they're collecting the building footprints for tax purposes, most probably. 911 locations are collected for emergency services.
If a residence were to be occupied at one point in time and later vacated, would it still be reflected on the 911 location map?
Yes, it would be.
Okay.
Even though there's not a resident there, it would still require emergency services for police, fire, et cetera.
So even that layer then would not, or sorry, that shape file then would potentially include buildings where no one resided,
Theoretically.
or that weren't currently operated as a business.
No, any addressed location, I believe, would be in that 911 address.
I suppose my question is, do you know whether information is culled from that shape file when there is no longer a business operating at that location or no longer a resident living there?
That would be a question for the Washington County GIS department.
Okay, so you do not know.
No, I relied on their data.
Okay. I just, I think I have one more question. In drawing the pink bubbles, for lack of a better term, that we see here on Figure 5, you measured out what 2,500 feet would be from the edge of any of those red polygons to draw those pink bubbles, correct?
What we do is we analyze, we take the occupied building structures, and then we buffer them by 2,500 feet, and then that obviously creates a series of bubbles, as you described it, and that's how you get that round edge image, I guess you would call it.
Are those bubbles drawn in two-dimensional space, or do they follow the topography of the land?
They're drawn as the crow flies.
Okay, so it could be that if, for example, a house is up on a hill, that actually, as the crow flies, a location that is 2,500 feet as the crow flies would be actually more than that distance if you were to actually walk it on the ground, correct?
Theoretically, yes, it would be. It might be a little bit further. Let's say you would walk down a hill, across a valley, and up the other side. It might be a little bit further than 2,500 feet. But the ordinance does not. The ordinance just sets a buffer distance. It does not say, a ground measurement from each of the structures to an available area.
Well, even if we were to imagine this in three-dimensional space, though, and you had a 2,500-foot bubble around a building, that would not necessarily, you could actually have a building as the crow flies that's 5 feet, but if there's a steep enough grade, that bubble would not be touching anything at the bottom of that cliff, correct?
For the topography of Washington County, it's going to be an irrelevant difference.
Okay, but you did not, even in some of these instances where it looks like there might be space here or there, or that it's fairly close, as in the 2 examples that Range's counsel pointed out to you, you don't know the topography in those locations,
I
correct?
did not analyze topography.
Okay, no further questions. Thank you, Mr. Oh, excuse me. Oh, I do have one more. I apologize, Mr. Lindbruner.
That's all right.
Because Range has no concrete plans, as you answered earlier, that you were informed of for any new well pads, any new drilling, you would not be able to tell us anything about the lay of the land at the time that it is ready to actually drill a well, correct?
Restate that question, please.
Well, your mapping reflects conditions frozen in time at the moment that the data was collected that you compiled into the mapping exercise, correct?
That's correct.
And so it would say nothing if, for example, Range wants to drill a well in 10 years. None of this data would be, this data would be stale. This mapping would be stale at that point.
10 years from now, yes, definitely. Someone would go through this process again to analyze to see if there was any potential area to locate a well pad in.
Okay. Thank you. I think I'm actually done this time, Mr. Lindbruner, so I appreciate your answers.
Good evening, Mr. Lindbruner. My name is Joshua Brown. I represent Georgetown Estates and HOA here in Cecil Township. I'm going to be brief and make sure I'm not hitting you with repetitive questions here. But real quick, Pennsylvania, do we have a minimum setback for the whole state?
I believe there is, but off the top of my head, I can't say what that distance is.
Is that 500 feet? Does that sound right?
It possibly is, but I can't confirm that.
Okay. You didn't do any analysis for tonight, what the default setbacks, the default buffers would look like on a map like this. Is that fair?
That's correct. My assignment was to analyze the buffers outlined in the ordinance only.
Okay. And you didn't analyze the prior ordinance prior to this 2024 and 2025 ordinance passed here in Cecil Township, what those buffers would have looked like. You didn't do that analysis here tonight either?
No.
Okay. And earlier you mentioned about doing an analysis. You'd have to do an analysis. I think you said it would be a fairly large analysis to look at all the potential waivers, that sort of thing.
Mm-hmm.
I believe that's what you said. Fairly
Correct.
large analysis.
Right.
In an ordinary course at your job at Range Resources, when they bring a well site to you, are those well sites already pre-leased at that point, or do you provide instructions for the landman to go out and then lease a certain area? What's the order of operations there?
I don't provide any direction to any other department other than my own. The process, when we're asked to analyze an area, there may theoretically be a well there may not.
Okay. So
I believe that was your question.
yeah. So when you do your analysis, you're not considering whether or not it's leased at that point.
That is correct.
Okay. And as far as you know, Range Resources would never drill in an area that they don't have leased. Is that right?
That would be called a trespass, and we
Okay,
do not
I
do
agree.
that.
Okay. I have no further questions.
Do any other objectors, council, have questions? No. Ms. Brown, do you have any redirect?
No redirect.
Okay. Members of the board, do you have any questions for the witness? Neither do I. And with that, thank you, sir.
Thank you.
Mr. Volz, with your permission, we're ready to call our next witness.
Please do, yes.
We note that the time is 9:05. We would like to continue, we would like to complete this witness's testimony tonight. It is not expected to be long. But if we're going to start, we'd like to not have to call her back again.
I think it would be in everybody's best interest to get this witness's testimony on the record tonight, and including cross-examination. So if we go beyond 10 o'clock, that's fine. I say we continue moving forward with this.
Thank you very much.
Just as a housekeeping matter, is this Range's last witness?
It is Range's last witness. We have a few other evidentiary issues to introduce into the record, but those shouldn't take very long.
Okay, great.
We're calling to the stand Sarah Black.
Raise your right hand and be sworn, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Good evening, Ms. Black. Could you please state your full name and spell your last name for the record?
Sarah Black, B-L-A-C-K,
Where are you employed, Ms. Black?
at Range Resources Appalachia.
And how long have you worked for Range?
I started full-time in August of 2014. I also interned there the summer of 2013.
Were you a student intern for Range in 2013?
Yes, it was after my second year of law school.
Did you graduate from law school?
Yes,
And are you a licensed to practice in the state of Pennsylvania?
yes,
What year did you graduate from law school?
2014.
When you returned to Range after graduating from law school, what position did you hold?
My first position was as a landman one.
And what were your responsibilities as landman one at Range?
I was responsible for procuring oil and gas leases in a certain geographical area.
Did you work within a particular department within Range as a landman?
Yes, the leasing team is part of the land department.
During your employment with Range, how long have you held a role within the leasing team?
I was a member of the leasing team until February of this year.
What does the leasing team do?
The leasing team is responsible for executing and negotiating oil and gas leases. We work with many different departments at Range, but I would say the three most pertinent departments would be the planning team, the drilling team, and the development team.
How does Range determine where it wants to obtain oil and gas leases?
That's going to be a collaborative discussion with many departments at Range.
You mentioned before the planning team. How do the leasing and planning teams work together to identify acreage to target for development?
So the planning team is responsible for our drilling schedule. That's going to say when the drilling, completing, and wells are going online. So it's up to the leasing team to be able to get the leases that we need in order to maintain that drilling schedule.
You mentioned a development team.
Yes.
How do the leasing and development teams work together to identify acreage to target for development?
The development team has three main responsibilities. They are establishing units, which is a collection of oil and gas leases. They are running title to determine ownership of the oil and gas and performing curative work. So the development team is putting together their collection of leases or their unit, and then the leasing team is responsible for obtaining those leases within the unit.
You also mentioned a drilling team.
Yes.
How do the leasing and drilling teams work together to identify acreage to target for development?
So the drilling team are the folks who are actually physically drilling the oil and gas wells. The drilling team is going to determine the reachable acreage, and then the leasing team is going to target that acreage for development.
Do you
You mentioned that the drilling team determines the reachable acreage. Reachable from what?
From the existing range well pads.
Have you been involved in all of these different aspects of the leasing team's work with the planning, development, and drilling teams?
Yes.
Now, prior to your recent position change, what was your position within the leasing team?
The last position I held on the leasing team was a staff landman.
What were your responsibilities as staff landman?
They were generally consistent with a landman one, but they increased in responsibility, supervisory responsibility, and geographic area.
How did your responsibilities as staff landman compare to the responsibilities you had earlier in your career at Range?
When I began at Range, I was just responsible for Nottingham and North Strabane townships. As a staff landman, I was responsible for those townships and about 50% of our townships in Beaver County. I was also taking on more supervisory work and more sophisticated projects.
In response to my next question, if you could just move slightly closer to the microphone. Over the course of your career at Range, do you know how many leases you've personally procured?
I have taken over 870 leases myself.
And have you had any responsibility for leases beyond those 870 that you personally procured?
Yes, I have been responsible for overseeing thousands of leases.
And in what way have you overseen those leases?
So I was responsible for managing a team of brokers in the field. They were the ones negotiating the leases with landowners. I would set the terms, draft any addendum provisions, and then I was also responsible for proofing those leases and approving them once they came into Range.
You mentioned that you had a recent position change. What is your title at Range now?
I'm currently a district land manager.
Is that a more senior role?
Yes.
Based on your experience, are you familiar with Range's leases and the oil and gas rights within those leases?
Yes.
Generally, what is an oil and gas lease?
An oil and gas lease is an agreement between an oil and gas owner and an exploration and production company wherein the oil and gas company stands in the shoes of the oil and gas owner and is able to develop the underlying resource.
And in this case, what are the underlying resources?
The oil and gas or what any other constituents that are mentioned in the lease.
Is there a distinction between surface rights and non-surface rights in oil and gas leases?
Yes.
What is that distinction?
A non-surface lease would just allow the oil and gas company to develop the resource from a different surface location. Whereas a surface lease would allow the oil and gas company to put infrastructure on the surface. That could be well sites or pipelines.
Under a non-surface oil and gas lease, what are some of the primary rights that Range is generally authorized to exercise in its leases?
The ability to develop the oil and gas as if they were the landowner.
Is it fair to say that the oil and gas lease allows Range to exercise specified rights with regard to oil and gas that the owner of the property would otherwise hold?
That's correct.
Does Range ever use the term stranded to describe any of its leases?
Yes.
What does that mean?
It means that the acreage would not be able to be reached from a Range operated well site.
Range's oil and gas leases follow a similar form.
Yes.
What are the standard components of a Range oil and gas lease?
First, you're going to have the oil and gas lease itself. That's going to lay out the parties, a description of the property, royalty amounts, and other what we call standard terms. You're also going to have a confidential pay letter that's going to describe the upfront bonus amount. You may have an addendum, which will be individually negotiated lease terms.
Once Range and the landowner have executed a lease, is anything filed with the county?
Yes, we file a memorandum of lease.
And what is a memorandum of lease?
A memorandum of lease is a concise summary of the lease that's just going to explain the property and the parties. It's necessary to put subsequent purchasers on notice of the lease without giving away any confidential information.
Are you familiar with Range's leaseholds in Cecil Township, Pennsylvania?
Yes.
How are you familiar with those?
I myself have negotiated and executed numerous leases for properties in Cecil, and I have overseen leases that were taken in Cecil as well.
I'm going to run through a few exhibits with you. Could you please review exhibits 12 through 17? And we're going to hand these out to council and the board as well while you do that.
I'm ready when you are.
Okay. Have you reviewed exhibits 12 through 17?
I have.
Do you recognize the documents?
Yes.
What are they?
They are 4 oil and gas leases and 4 memorandums of lease for properties in Cecil Township.
Do the oil and gas leases have any redactions on them?
Yes, I can see that they have redacted payment terms and also addendum provisions.
Does the redacted confidential information include payment terms for amounts paid to the landowners under the leases?
It does.
Did Range make payments to the landowners per the terms of the leases identified in Exhibit 12 through 17?
Yes.
Are the leases represented by the documents marked as Exhibit 12 through 17 stranded?
Yes.
Are the leases represented by the documents marked as Exhibits 12 through 17 surface or non-surface leases?
These are all non-surface leases.
Let's look at Exhibit 12. Are you there?
Yes.
You recognize that exhibit?
Yes.
What is it?
It is an oil and gas lease between Range and John Lejevic.
Does Exhibit 12 cover property located in Cecil Township?
Yes.
Please turn to Exhibit 13. Is this the memorandum of lease for the lease marked as Exhibit 12?
Yes.
Please turn to Exhibit 14. You recognize this document?
I do.
What is it?
It is an oil and gas lease between Range and the Michael Monaco Trust.
Does the lease marked as Exhibit 14 cover property located in Cecil Township?
Yes.
Please turn to Exhibit 15. You recognize this document?
I do.
Is Exhibit 15 the memorandum of lease for the lease marked as Exhibit 14?
Yes.
Please turn to Exhibit 16. You recognize this document?
I do.
What is it?
It is an oil and gas lease between Range and the Polinos.
Does the lease marked as Exhibit 16 cover property in Cecil Township?
Yes.
Please turn to Exhibit 17. You recognize this document?
Yes.
Is this the memorandum of lease for the lease marked as Exhibit 16?
Yes.
I'd like to offer into evidence Exhibits 12, 13, 14, 15, 16, and 17 into the record.
Any objections?
Objecting on the basis of relevance.
We'll allow it. They're marked and they're in evidence.
Ms. Black, if you could go back, could you count for me, just to clarify for the record, how many leases are before you in your binder between Exhibits 12 and 17?
3.
I have no further questions.
Ms. Moore, are you ready to cross-examine?
evening, Ms. Black. Let's talk first about outlining a little bit about what you do and what you don't do at Range Resources, okay? I think you just said your most current position is District Land Manager, correct?
Yes,
Okay, so currently, you are managing a group of land agents, is that fair?
I am no longer on the leasing team. I am currently on the development team.
Okay.
Where I am managing our title and curative.
Up until you became a district land manager, you were working with the leasing teams, right?
Yes,
Okay, but at this point, you are now on the development team.
correct.
Okay, very good. Any of the leases you showed us today, do they have anything to do with oil and gas facilities in Cecil Township, or are you only talking about well pads?
I'm not sure that, could you rephrase?
On any of the leases you showed us this evening, are these all for the leasing of oil and gas subsurface rights? Is that correct?
Correct.
Okay. On any of those leases, is Range seeking to put an oil and gas facility on any of the properties?
I don't have knowledge of that.
Okay.
These are non-surface leases, but.
Okay, very good. So all of these leases are you're just talking about subsurface rights. You do not have access to anybody's surface rights on these leases you showed us this evening, correct?
Correct. If we wanted to use the surface, we would separately negotiate.
And you haven't for these 3 leases.
I don't have knowledge.
So that's a no. You're not showing us a surface lease, correct?
These are non-surface leases.
Okay, thank you. Is Range seeking approval from any entity at this time for any new well pad or other oil and gas facility within the boundaries of Cecil Township?
I don't know.
You're unaware, or is the answer no?
I don't know if there are negotiations ongoing. I'm not aware.
Okay, not talking about negotiations necessarily, but we'll go through the sequencing a bit. But at this point, does Range Resources, do you know if they are seeking approval for any well pad or any oil and gas facility in Cecil Township? So seeking approval from any entity.
I don't know.
As a district land manager, is that something you would be familiar with?
No.
Why not?
It's not within my scope.
Okay, so your scope of responsibility is to work on the development of leases for where Range wants to put a well pad. That fair?
Yes, I'm generally aware of the locations of our well pads.
Well, you're generally aware of the existing well pads, I'm sure, is that right?
Yes, I couldn't name one, but generally aware of them.
Okay, and because your job responsibilities are to work on the development of leases for well pads, you should be generally aware of where Range wants to place a well pad, right?
I'm not aware of every location that Range would like a well pad and the negotiations associated with it.
Okay, how about let's focus on Cecil Township. Are you aware of anywhere in Cecil Township where Range wants to put a well pad right now?
I'm not.
You're not aware of any location?
Correct.
Okay. But you should be aware as part of your job responsibilities. If there were a well pad that Range was looking to place in Cecil Township, you would be aware. Is that right?
Objection, asked and answered.
I'm just trying to get a clear answer from this witness about whether it's part of her responsibility to be aware, and is that why, whether or not she doesn't know, or whether, just trying to get a clear answer.
That question was asked and answered.
Sorry, my mic wasn't. You can answer it again.
I would say that I am fulfilling all of my job duties.
Okay. So I'll break it down a little bit. As district land manager, is one of your job duties to be responsible for the development of leases for a new well pad in Cecil Township. We're just talking about Cecil. Okay. How would you define your job responsibilities as a district land manager?
I manage the title and curative teams, so I am responsible currently for procuring title, abstracts, deed searches, bring downs, and managing all of the curative work. So that would be, affidavits of well site, affidavits of lease well status if wells are still producing in the area.
Yeah, so, and that job you just started in February of this year?
Correct.
Okay, so just a couple months ago?
Yes.
Okay, and before you were a district land manager, you were a staff land manager, right?
I was a staff landman.
Landman, okay. And when you were a staff landman, part of your job responsibilities was to work on the development of leases for new well pads in Cecil Township, right?
I was responsible for procuring leases in Cecil. When we're talking about well sites, that's going to be part of our surface land department, of which I have never been a part of.
Okay, so let me see if I'm clear here. You were just, when you were we're going back to staff landman. When you were a staff landman, one of your job responsibilities was to procure leases.
Yes.
Right, to go talk to the individual landowners and sign them up. And get some of these things that we just saw in Exhibit 12 through 17, right? Get those leases signed up, right?
Yes.
Okay, and when you were signing up leases, were you signing them up for any particular well pad, or you were just signing up the oil and gas, tying up the oil and gas rights with the landowner?
There are many reasons to take oil and gas leases. Some are related to a specific pad, but other times we are taking leases without a specific pad site in mind.
Okay, so you could do either way. You could just sign up the oil and gas rights in the hopes that in the future you may want to do something, Range may want to do something with those oil and gas rights, correct?
Yes.
Okay, or you could sign up the oil and gas rights, the subsurface rights, because there is a well pad in that area for which you need to lease the subsurface rights in that area. Is that fair?
Yes.
Okay, it could be one or the other, right?
Yeah.
Okay, so the three leases you talked to us about that were set forth in Exhibit 12 through 17, were any of those leases signed? First of all, were you directly involved in these leases?
I believe I negotiated the Polino lease.
And was that negotiated and signed up to fall into that first category or the second category? So were you just was Range signing up the oil and gas rights just to hold them? Or was Range signing up those oil and gas rights because it had a well pad at the time to connect, for which you wanted to connect those subsurface rights to?
I think that I would disagree with the idea of signing up oil and gas rights just to hold them, but I don't have any particular recollection about this lease as it applies to a specific pad.
Okay, so for any of these leases set forth in Exhibits 12 through 17, were any of these leases signed up for the purpose of being tied to a particular well pad, to use your language?
I don't have personal knowledge.
You just don't know.
I don't know, yes.
Okay, now you've spent your career with Range, correct?
Yes,
Okay, and a lot of it in leasing, right?
correct.
Okay, so you're generally familiar with the sequencing of events to get to a new well pad site, aren't you?
I have difficulty with the idea that there's a specific sequence of events, but I understand the general process.
Okay. So, and you can help correct me if I'm wrong here, but I'd like to understand the sequencing, and I'd like you to help me walk through it. So, first, Range does some geological studies to determine if and where it wants to place a new well pad site. Would you agree with me?
I wouldn't say that there's a consistent process.
Okay. So sometimes it goes one way, the sequencing goes one way, and sometimes it goes another way, right?
Yeah, I would just say in general, it's a very collaborative process where it's not necessarily steps 1 through 10. It's departments working together.
Okay. But generally speaking, there is a need to do some geological studies to determine if and where Range wants to place a well pad. Would you agree with me that you kind of have to do some exploration first to see if you even want to put a well pad somewhere?
Yeah, I would agree that we do geologic studies.
And that comes earlier in the process. You'd agree with me, right?
I don't have a lot of knowledge about that.
Okay. Well, you don't go get a permit and then do a geological study, right? You don't get like a permit from the DEP and then go do a geological study. Is that right?
I don't know that.
Does that make sense?
I don't know.
Okay. And do you typically sign up a bunch of subsurface rights leases and then figure out whether you want to put a well pad there? Does that happen?
That can happen.
Okay. And it could also happen the other way, where you Range decides to put a well pad and then goes and leases the subsurface rights in that area, right?
Yes.
Okay. And I think you already told us for exhibits 12 through 17, you're not sure which process we were talking about for these leases.
Correct.
Okay. Well, you use the term stranded for these leases, right? These 3 leases.
Yes.
Okay. And why are they stranded?
Because they are not able to be reached from an existing Range well pad.
Okay. And are you able to show us on the map where these 3 leases are? Where the land associated with these 3 leases are?
No.
You don't know where it is?
No.
Okay. The addresses are on the lease though, right?
Yeah, the addresses and the tax parcel
Okay.
information easily accessible on the county website.
Okay. And when you said you can't, Range can't access these 3 leases from any of its existing well pads, you mean that Range can't access them from the 5 well pads it currently has in the township? Is that what you're saying?
Correct.
Okay. Can Range access them? Have they explored whether they can access these particular subsurface rights from anywhere outside of the township, from a well pad anywhere outside of the township?
There's nothing stopping a well from being drilled in between township lines, but I'm not aware of any specific location outside of the township to drill into.
Okay, well, before coming here tonight and telling the board that these 3 leases are stranded, have you done any of that research? Have you done any of that inquiry to determine whether these particular properties can be accessed from other locations?
I'm sure it's been part of the analysis, but I'm not personally aware of
Okay.
any locations that we've determined that these properties can be reached from.
Okay, so when you say stranded, what you mean is that Range can't access these 3 leases from those 5 well pads. Is that what you're saying?
Yes.
Okay. Now, you're aware, Ms. Black, that you can't force landowners to lease their oil and gas rights in Pennsylvania, right?
Correct.
Okay. You actually have to sign each property owner up with a lease to access their subsurface rights, correct?
Yes, in order to obtain a lease, the oil and gas owner have to execute it.
There's no forced pooling in Pennsylvania, right?
Not that I'm aware of.
And you have to pay these landowners for the rights to access their oil and gas rights.
Commonly, an upfront payment is part of the negotiation.
Okay, and I think you said for the 3 leases set forth in exhibits 12 through 17, you've already paid the landowners at least a bonus payment, right?
Correct.
Okay, but you haven't paid them any royalties yet because you're not accessing those particular leases. Okay. When you were a staff landman, was part of your job responsibilities to do any analysis into, looking into where any new well sites would be? Was that part of your job?
No,
Whose job is that? Which group?
I would say primarily the surface land group.
Now, I think I heard earlier you are an attorney, correct?
Yes.
Okay. And you're familiar with the municipalities planning code, correct?
I'm not.
Oh, okay. All right. Well, as you sit here as an attorney, can you please point us to a specific landowner interest that Range has that forms the basis of this challenge?
Calls for a legal.
I'm going to allow it because she introduced the leases into evidence.
As I said, I'm not aware of the code.
Okay, so you can't tell us what landowner interest Range is here asserting as part of this challenge, correct?
Correct.
Okay. You talked a little bit about different types of leases that Range may enter into with a landowner, right? You could have they could lease subsurface rights, correct?
Yes.
They could lease surface rights, correct?
Yes.
And in some instances, they may lease both from the same landowner, right?
Yes.
Okay. And if Range is leasing the subsurface rights only, Range has no authority to step foot on that landowner's property, is that right?
I would have to look at the specific language in the oil and gas lease. I couldn't say it broadly.
Okay, well, if a landowner leases its surface rights to Range, they actually would enter into a separate surface use agreement, is that right?
No.
Okay, at what point does the surface use agreement come into play?
It may not. Many oil and gas leases allow surface use activities, so there would not be a need for a separate agreement.
Okay, so there may be instances where Range is leasing the subsurface rights and has some surface access built into the lease, right? That's one example.
Yes.
Okay, and there's other examples where Range is actually leasing the surface rights, and if they do that, they would enter into a surface use agreement, correct?
Can you rephrase?
Okay, I'm trying to understand the different types of leases. You talked a little bit about them on your direct. One of them is you are leasing the subsurface rights. So Range is leasing somebody's subsurface rights.
So in an oil and gas lease, we're always leasing the subsurface rights.
Okay. And sometimes, I think you said, when you lease those subsurface rights, you may include some surface rights within the lease, correct?
Yes, the lease will be specific about what rights it grants. And sometimes it grants limited surface rights, and sometimes it's a full grant of all surface rights.
Okay. And if Range desires to access all surface rights, typically they're going to pay more to that landowner to access all the surface rights, correct?
I wouldn't say so.
Okay, so would Range pay less to access someone's surface rights?
The amount that Range pays is dependent on a lot of different factors, and surface versus non-surface can be part of that, but I wouldn't make it a blanket statement.
Okay, so if you want to erect some structures on somebody's property, you need that surface right lease, right? You need a surface rights lease.
Or separate surface use agreements.
You need some kind of legal authority to be able to do something on the surface of somebody's property, correct?
Yes.
Okay, you need a lease or a surface use agreement or something, right?
Yeah, I think there's many ways that you can get permission to.
And the individual landowner can negotiate all of those things with range, correct?
Yes.
Okay. An individual landowner can negotiate whether and to what extent it wants to allow range to utilize the surface of its property, correct?
I don't want to be overly particular, but there are instances where an oil and gas owner could grant access to a surface that they don't own.
Can you explain that to me?
An oil and gas owner could sign a surface use lease for property that they don't own the surface of.
How does that work?
This is oil and gas law. I didn't want to go down an avenue, but dominant versus a subservient estate.
Okay, so what you're telling us here is that not only can a surface owner determine, they can negotiate how much and to what extent they want to allow range to utilize the surface of their property, but they can also do that for a property where they are not the owner of the property. Maybe it's a subservient estate.
Well, they would be the owner of the oil and gas.
I'm talking about surface rights.
There are situations where the owner of the surface does not own the oil and gas.
Okay. And I'm not trying to make this super difficult. I'm just trying to understand from you, have you testify that owners of the surface of the property can negotiate with range to determine where and to what extent they want to allow range to access the surface of their property, right?
A surface owner can negotiate with range.
Okay. And they can determine to what extent, how much, and where they want to allow range to access their property, correct?
Yes, that is something that they can negotiate with range.
Okay. So, the landowner can decide, like they're kind of in the driver's seat, they can decide, right, whether range accesses their subsurface rights and whether range accesses and to what extent range accesses their surface rights, correct?
Can you define what you mean by property owner? Or when you say that, do you mean the owner of the oil and gas or the owner of the surface?
Okay, so what I'm trying to understand from you, and I don't think this is really difficult, that an owner, okay, let's break it down. An owner of subsurface rights, I'm not concerned about that right now because we're talking about the use of the surface. Okay, so either the owner of the surface rights, right, they have the ability to determine how much of their land they want range to use, right?
In some situations.
Are you saying they don't have a say in other situations?
I would say an oil and gas owner has the ability to sign a surface use lease for property in which they do not own the surface.
Wow. Okay. So let's focus on the example where the landowner owns the surface of the property, okay?
The oil and gas owner owns
Yes.
the surface?
Yes. So the person who owns the land owns both the oil and gas and the surface, okay? Like that's the basis of this next question. That particular landowner can choose, if they allow range onto the surface of its property, they can choose where they want to site the well. So they could push it back, and they're going to put a well pad on. They can push it back as far as they want, right?
I am not on the surface team, but I am aware that the landowner is not, there are limitations as to where well sites can go based on the topography. So it wouldn't be a decision entirely made by the surface owner.
Okay, so maybe not a decision made entirely by the surface owner because you said, so topography is in play, right? Correct?
Yeah.
Okay, and the surface owner's say is in play to some extent, correct? In the negotiations?
Yes.
Okay, and range is certainly they're part of this negotiation, right?
Yes.
Okay, but the neighboring property owners are not part of that negotiation, right?
I wouldn't know the specifics. Like, you would have to look at the specifics of the negotiation.
Okay, but typically, when we're talking about accessing someone's surface rights, right, and we're talking about, for this example, placing a well pad on their property, okay? The property owner is part of the negotiations and range is part of the negotiations, correct?
Yes.
Okay, and typically not the neighboring property owners, right?
I would say unrelated individuals are commonly not part of the negotiation.
Okay. So these unrelated people in Cecil Township, unless they are actively negotiating with range, right? They don't have any say in terms of siting of a well pad, right?
Correct.
Okay, the only protections they have are what the zoning ordinance says, right? That's the only protection they have, correct?
I am not aware of all of the protections.
Okay, well, one of the protections they have is the township zoning ordinance, right?
Yes, I don't have any knowledge of the ordinance, but it's my understanding that there are setbacks in the ordinance.
Okay, and within a township zoning ordinance, the Board of Supervisors makes decisions based on health, safety, and welfare to determine where and how large a setback should be as it relates to a well site. You have a general understanding that that's the case?
I do not.
Okay. You do understand there are setbacks in zoning ordinances, right?
I have listened to these hearings. I have knowledge based on that.
Okay, are you generally aware? I mean, you're a lawyer and you've been in this line of business for a long time. You're aware that there are setbacks in any township zoning ordinance, correct? You're familiar with the concept?
I understand what a setback is.
Okay. And as it relates to an oil and gas well site, you've heard at least tonight, there are setbacks in Cecil Township's zoning ordinance, right?
Yes.
Okay. And you're aware that the Board of Supervisors makes decisions on where those setbacks should be and how, taking in health, safety, and welfare, taking in appropriateness, they make a decision on where those setbacks can be.
Objection. Lex Foundation.
To the extent you can answer the question.
I do not have any personal knowledge as to what the Board of Supervisors takes into account.
So just so I'm clear, Ms. Black, the point of your testimony then tonight was to tell us that there are 3 leaseholders that you believe are stranded because one of those 5 well pads can't reach their oil and gas rights. Is that it?
I'm not sure that I can say what the point of that is.
Okay, yep, neither can I. I'm done, thank you.
Attorney Black,
Mr.
White Ferguson. Range, through its development team, has access to mapping and information showing the parts of Cecil Township to which Range already has access. to extract oil and gas. Is that correct?
I'm not sure, can you clarify what access means?
You're able to extract oil and gas already.
We have mapping software that shows our leasehold position.
Well, the leases that you've introduced are leasehold positions, but you're telling us specifically that they are not locations where you're extracting oil and gas, right?
We do not have surface rights under these leases.
Okay, let's go back to my question, okay? My question is, doesn't Range have mapping and information that could show the areas of Cecil Township in which it is currently extracting oil and gas?
Yes, we have maps that show our current well pads where we are extracting oil and gas.
But you extract oil and gas beyond the well pad, don't you?
The point at which it reaches the surface is at the well pad.
I'm not confused about a well pad is. I'm talking about the units from which you're extracting gas. You have unit maps covering Cecil Township, don't you? And you know from which properties you're extracting oil and gas.
We have on our maps outlines of the units. And we have the well bores, the well pads, the leases. Those are all things.
The question is,
Objection.
don't you know
We
the
allow,
areas?
objection, we allow the witness to finish her answer before the next question.
To be fair, he has asked a specific question 3 times. So Mr. Ferguson understood, let her finish her answer, but can you ask that question again for the witness to answer?
Do you understand the question?
I'm not sure that I do.
Okay, so my question is, wouldn't Range be able to show on a map of Cecil Township all of the properties from which they are extracting oil and gas?
You would be able to see on a map all of the leases that are within units in which wells are drilled.
Are you just evading the question?
I'm not, no.
Okay, because you're the same person who introduced leases from which there's no oil and gas being extracted. So obviously a map of leases is not responsive. I'm asking you whether you have maps that show the properties from which oil and gas is being extracted. That wouldn't include leases from which oil and gas is not being extracted. But do you have such maps?
A map that would show the tax parcels that are included within the physical boundaries of a unit? Yes, we would have that.
From which you're extracting oil and gas.
That are within the unit in which a wellbore is.
What's the answer to that? If you want to finish the question that way, okay, what's the answer?
Can you repeat your question?
No, I'm not. We're just going to accept that you're not willing to answer it. Did you provide any of that information to Mr. Limbrunner?
What?
Did Range provide information about mapping about where the current leases are to Mr. Limbrunner?
Mr. Limbrunner has access to that information.
So the answer is yes. All right?
I'm saying no one person provided him with the information that he
Okay.
has access to.
All right. Now, the leases which make up, and the memoranda of leases which make up exhibits 12 through 17, did you review these before this evening?
Yes.
Okay. So we can agree that all of these leases were entered into prior to the enactment of Ordinance 9 of 2020.
I am not aware of when the ordinance was stated.
You don't know when the ordinance was enacted? It was in 2024. And every one of these leases precedes 2024. Isn't that right?
The first lease I'm looking at is dated in 2024.
Exhibit 12?
Exhibit 16.
Oh, Well, why don't we start with the first one then? That's dated 2023, right?
Yes.
Okay. The next one is Exhibit 14. That's dated 2023, right?
Yes.
And the next one is Exhibit 16, and that's dated May of 2024. That's a delay rental lease.
Correct.
Okay, what's a delay rental lease?
So the two common types of leases are a paid-up lease, where your bonus payment is the one payment that you get that will hold the lease for commonly 5 years. A delayed rental lease means that those payments are spread out across 5 years. So looking at the terms and conditions of the lease, they're going to be different, but commonly, if development has not commenced at the anniversary date of the lease, then a delayed rental payment is made.
Okay. Now, let's just look at exhibit number 12. And it refers to, at the very last page, which is page 5, refers to other instruments associated with this lease, which is 26's memorandum of lease, which you have attached as the next exhibit, paid up lease form. Next is the surface use restriction clause, and 29 is an addendum and pay letter attached. Let's turn back to the page 8. It says confidential exhibit A. Is that part of the addendum?
No.
That's the confidential pay letter, right?
Yes.
Okay. Because in paragraph 29 it says confidential pay letter which is labeled exhibit A, which are attached here to and made a part hereof. Now you told Attorney Moore that there really wasn't much of a pattern here in terms of the process of negotiating a lease. Let's read confidential exhibit A, or let's just refer to this as the this is the confidential pay letter. Now, can we agree that every oil and gas lease has a confidential pay letter?
I would not agree with that.
Most of them do.
Many of
them.
Modern leases.
Okay. So the second paragraph, so this is, a person has signed this lease, that is the landowner already signed this lease, right? Then they get to the confidential pay letter. The second paragraph says, the lease is reviewed to ensure that the proper persons have appropriately executed the lease. In other words, you want to make sure that the person who signed the lease actually owns the oil and gas rights. Is that one of the reasons why that phrase is in there?
Yeah, Range commonly will run title prior to acceptance and payment of oil and gas.
Okay. That the oil, gas, and coal bed methane rights are intact and owned by the lessors. And it says the lands covered by the lease remain desirable to Range and determine the status of any other oil, gas, and coal bed methane leases that may be active on the leased premises without a certified title examination. Then the landman, never call anybody land persons, then submits the result of the title review along with the lease and a detailed map of the leased premises to Range for processing and approval. Then the lease is further reviewed by a member of Range's Land Administration Department. The property is placed on Range's land maps and the lease information is inputted into Range's computer system. Range management then reviews the lease terms and conditions thereof, and if approved, the accounting department is instructed to make the appropriate lease payments as they come due. So a person could sign the lease. I mean, this lease in particular, this person, the landowner, can sign the lease, and as it turns out, as the confidential, as the pay letter says, Range may just determine this is no longer desirable, and they do have the right to not accept the lease.
Correct.
Okay. So, is the viability of the extraction of oil and gas one of the items that is reviewed in connection with a lease of this form?
I don't understand viability of extraction.
Well, so there could be a geologic viability, right? And I suppose, do you even consider, if this is a non-surface lease and you are only entering a person's property or leased property from under the earth and not doing anything on the surface, does Range even care what the setbacks are in that municipality? If their activity is purely underground?
Yes, I would say Range would be interested and or concerned with the setbacks.
In the situation where you have a wholly non-surface lease, only drilling under a person's property, what conceivable interest would Range have in the applicable zoning setbacks?
Well, in order to develop a non-surface lease, it would have to be developed from a surface location.
Well, but now you're changing my question. I'm talking about this lease, this property, which is a non-surface lease, and the only activity in connection with this property will be to drill under the ground of this leaseholder's property. Does Range have any concern about what the setbacks are as to this property? And that's the one of the lease exhibit number 12 that we're talking about.
Yes, in order to develop the property a surface.
You're going to talk about another property, are you, Janelle? My question goes with this property at this lease. My question is, do you care about what the setbacks are applicable to this property?
Yes, I don't know.
How would they apply?
The proximity to a well site location.
On another site?
Yeah, the
Okay, so you can't answer that question without
Mr.
taking-
Ferguson, let her finish. She was in the middle of
Okay.
a sentence there.
Okay, go ahead.
So the ability to develop this lease is based on the necessity of a surface location. So you can't just look at this lease in a vacuum.
Now, ordinance number 9 of 2024 was enacted on November 4th of 2024 with an effective date 5 days later, which was November 9th of 2024. That's over 5 months ago. Are you aware of any actions that Range had to take in connection with its 5 permitted well pads or well sites in Cecil Township since the enactment of ordinance 9 of 2024?
Can you repeat the question, please?
Sure. So, Ordinance 9 of 2024 was effective on November 9th, 2024, 5 months ago. Do you know of any actions that Range has had to take in connection with its existing 5 permitted drilling sites or well pads in Cecil Township since the enactment of that ordinance?
I'm not.
And in the absence of any actual pending application for gas well development or drill site development, the enactment of Ordinance 9-2024 Cecil hasn't required any changes in connection with any of Range's existing well pads. Is that right?
I don't know.
You're not aware of Cecil attempting to retroactively apply the ordinance to existing well pads?
I don't know.
Has Range taken any steps to modify its leases with landowners to require the grant of a waiver to the spacing requirements as a condition of the lease?
I don't know.
And as the district, you're now the district land manager, is that right?
Yes.
And do you have is it within your authority to direct land persons to modify the terms of Range's leases that they offer to landowners? No. Who has the authority to direct those changes?
That would be the leasing manager.
The leasing manager. And is it within the scope of your responsibility, given your long experience, to make recommendations to the leasing manager as to terms that would be beneficial to Range to include in their leases?
No.
That's outside the scope of your responsibilities?
Correct.
And if you you were to make such a recommendation, you would be rebuffed for stepping outside the scope of your responsibilities? Is that why you would not make such recommendations?
I just haven't. I can't say what the reaction would be.
Okay. You haven't because you haven't had any occasion to make recommendations with regard to leases anymore?
Correct.
Okay. You understand that under the ordinance which is being challenged by Range, that there is no zoning district in the entirety of Cecil Township in which oil and gas development is not permitted?
I don't know that.
At the January 20th, 2025 hearing, a Range representative stated that Range's application, that is what we're doing here tonight, it's really a challenge, does not pertain to a specific proposed new oil and gas pad or other development. The exclusionary challenge relates to future actions. Has anything changed since that time? Since January of 20th of 2025?
I don't have knowledge of that.
The challenge was filed on December 27th, 2024, nearly 4 months ago. Has Range, to your knowledge, has Range experienced any hardship as a result of the zoning hearing board not having rendered a decision on the challenge yet?
I don't have personal knowledge.
And you don't know today whether or not the ordinance would affect any future actions of Range?
I don't.
And I think you said in answer to Attorney Moore's question that you don't know whether Range, in connection of this challenge, is a landowner, an option holder, a lessee, as to the future effect of the ordinance on its land holdings.
I'm not aware of the definitions of those.
And you're not aware of any third-party landowner that has asked Range to prosecute this challenge, as none's been identified?
I don't have any personal knowledge.
And you're not familiar with the waiver provisions, other than what you learned from our discussing them this evening with Mr. Limbrunner? And Range is not taking the position that Cecil Township doesn't have any right to set any distance from certain structures and oil and gas development. That's not the position Range is taking, is it?
I don't know Range's position.
Can you testify that that setback requirements from oil and gas development are certainly not unique to Cecil Township?
I am not aware of that.
You're not aware of whether any other municipalities in the Commonwealth of Pennsylvania have setbacks from oil and gas. That's your testimony.
I'm not aware of the specifics of any setbacks and what townships they are applicable to.
Okay, but you're aware that they have them.
I'm generally aware, yes.
Okay, Cecil Township isn't unique in its idea of having setbacks.
Sure.
And you're unaware of ranges and purporting to prescribe what an appropriate setback would be. Certainly, you're not here
I'm
to do
not.
that. Okay. That's all the questions I have. Thank you, Attorney Black.
Ms. Black, I just have a few questions for you. You referred to these leases as covering stranded acreage. How do you know they're stranded?
Based on my experience and my collaboration with other teams, I've learned what acreage generally can be reachable from a well pad.
And you'd agree with me that the determination of whether acreage is stranded is going to depend on a lot of different factors, correct?
Yes.
So, for example, there might be acreage that the technology just doesn't exist at this point in time to access gas under there.
Correct.
Or there could be acreage at which the technology exists, but the economics just don't work out. It would be too expensive to access that gas for the value that Range is likely to receive by selling it.
I am not personally aware of any economic considerations that went into the analysis of whether something.
Okay, but do you know for certain that that is not a consideration in determining whether or not something is stranded?
In this case, it was not.
Okay, there could also be property law issues. I think Attorney Moore mentioned that there is no forced pooling in Pennsylvania, and therefore Range might not have all of the property rights to access the pool of gas from which this acreage is comprised. Well, let me ask, as to these specific leases, do you know if Range has all of the property interests it would need to extract gas from under these specific properties?
I think we're a couple steps ahead. Without having a pad location, I don't know all of the leases that we would need in order to develop that well.
Okay, and there could also be regulatory restraints, correct?
I'm not personally aware of regulatory constraints, but I am aware that they exist.
Okay. Are you aware of whether or not regulatory constraints factor into a determination as to whether acreage is stranded?
It was not part of the consideration as to whether these leases were stranded.
And when you say that, does that include local land use regulation?
Just, these leases are stranded because they are unable to be developed from current Range well pads.
Okay. Are you able to say that but for the setbacks that are at issue in this appeal, you would be able, and it would be economic, to extract gas from under these properties?
I don't know that.
Okay. And so you don't really know if a ruling from this board would put Range in a position where it could actually take advantage of the gas under these properties?
Correct.
Okay. Do you know whether there are any leases in Cecil Township that are stranded solely as a result of the setbacks at issue in this appeal?
Can you repeat that, please?
Are you aware of any leases in Cecil Township that are stranded solely as a result of the setbacks at issue in this appeal?
I don't know.
Okay. I guess another way to say it would be, if these setbacks were removed, you're not aware of any leases that you know for certain Range would have every approval and be able to economically take advantage of that lease.
Correct.
Okay. The setbacks at issue in this case have been in effect in one way or another since I believe November of 2024. Is that your understanding?
I don't have any personal knowledge.
Okay. Well, let me ask, are you in charge of securing waivers from landowners for purposes of complying with the setbacks here?
No.
Okay. Do you know if anyone is in charge of that?
I believe that would fall under our surface land umbrella.
Okay. Are you aware of whether or not they've requested waivers from anyone?
I'm not.
Okay. Are you aware of whether Range has done any analysis of how many waivers it would need to access any stranded gas in Cecil Township?
I'm not aware of any analysis relating to waivers.
Okay. And that would include then any analysis of the cost, maybe, of obtaining waivers, either in negotiations or through contract.
Correct. I don't have any knowledge about any waiver analysis.
I think that's all I have. Thank you, Ms. Black.
No redirect, Your Honor.
Any questions from the board?
Mr. Volz, is Ms. Black excused so she can go?
Yes, she is. Does Range Resources have any other witnesses?
No other witnesses, but we do have 2 evidentiary issues to offer.
Okay, let's move on to that.
Mr. Volz, Range offers Exhibit 18. This is a certified copy of August 26, 2024 letter from the Washington County Planning Commission, Cecil Township Board of Supervisors, regarding the proposed ordinance from last year. We'd like to offer this into evidence. It is self-authenticating under the rule, given that it's certified.
Any objections to this letter?
So, yes, I mean, first of all, relevance, but second of all, the County Planning Commission issued a series of letters in response to numerous versions of the ordinance that by the supervisors, which is not a big deal. And I would say you cannot, if you're going to look at one of the letters from the county, then all of them should be included in the evidence. So you can't just pick and choose.
I think
Okay.
it re-
We'll allow this, and if we proceed beyond this, the township will be able to submit other evidence that will be most likely accepted into the record based on the same rationale.
Thank you. And then lastly, this is not being, the physical copy that we provided was just to allow you to read along. But I am offering into evidence statements from Board of Supervisors Chair Tom Cacciola, made as reflected in the May 8th, 2024 transcript of the zoning hearing ordinance hearings, starting on page 4 of the transcript. Osceola states as follows: I want to mention one thing. We've got a lot of comments, mostly emails, standard emails from our residents and plans, and they're asking the township to put a 2,500-foot distance from protected structures. We have to follow the law. The municipality's planning code tells us that we can't ban business from the township. So we can't outright ban drilling, but we also can't pass distances where they can't possibly drive anyhow. We have maps that show 1,500 feet, which we're going to show you that there are a few spots that would be open for drilling. If we go to 1,600 or 1,700 feet, they're got. And the law says we can't ban them. That is effectively banning them by zoning. Then starting on page 5, line 5, Mr. Cacciola again. The board still has to follow the law. It doesn't matter if you would like it to be 2,500 feet. We can't do that. You're going to see the maps. Just look at them, and you'll see another map with less spots that may be workable. And on page 5, line 22, Mr. Cacciola. We're going to have a professional give some testimony first. Understand the maps you're going to see. We just cannot disobey the law. If you have an issue with that, law comes from the state. Then you have an issue with our state legislators. Change that. We have to follow it. Nobody on this board can vote for something that violates the law. So you will see that 1,500 feet in some spots work, but again, we're working on it. With that evidence, range rests.
And I'd like to place some objections on the record.
Okay. Ms. Moore?
Thank you. First of all, Mr. Cacciola is not a lawyer, so he cannot opine on the law. Second of all, this board underwent an extensive series of hearings. There were at least 5, maybe 6 hearings related to this matter. And just like you would a deposition transcript at trial, you can't cherry pick bits and pieces. And if you're going to put in a portion of this transcript, I would offer that the entirety of all of the transcripts of all of the hearings should be entered into evidence and not just this one piece. Finally, there is a waiver concept that this board ultimately came up with towards the end of the series of hearings. And that waiver concept is included in the final ordinance, which has now been repealed, so it doesn't exist anymore. But it is included in ordinance number 5 of 2025, and it's also included in the oil and gas facilities section of ordinance number 5 of 2025. So that waiver concept is a concept that the board ultimately came to a conclusion on that was not in effect in May of 2024.
To that objection, I'd just like to add that I don't know how to characterize the introduction of a transcript of a person making repeated statements about violating the law by enacting a 2,500-foot setback, where the party offering this as evidence has already rested without attempting to actually corroborate what law is he talking about. There is no such law. And so it's simply misleading. It doesn't really have any place in the hearing because they've already rested and they can't offer anything that he's talking about other than some opinion that he may have. I believe you had an objection.
Yes, just echoing what Ms. Moore and my colleagues said down at the bottom of the table. This is obviously, I would say this is hearsay. If they wanted to have Mr. Casiola testify, they could have brought him here, testify. As Gretchen, Ms. Moore said just a minute ago, there was multiple revisions of this ordinance after these statements were made. I mean, so it's not relevant, it's hearsay, it should not be admitted.
I would also just add briefly that usually transcripts involve some sort of oath that's given to someone who's testifying, and I don't believe that there's any indication or any statement that these were statements provided under oath, which I think would distinguish this from other sorts of deposition transcripts or trial transcripts.
Just playing devil's advocate, why would this not be a statement against interest from the one of the township supervisors, cautioning the acknowledgement that Mr. Casiola is not an attorney. Mr. Casiola cannot make binding legal determinations on the township, but just accepting this as evidence of something that he said, why would that not be relevant to this proceeding as a statement against the township's interest?
Mr. Casiola himself is not the party, right? The
Mhm.
party is a board which can only act by a majority of the board. So Mr. Casiola on his own doesn't find anything or anyone. And I would reiterate again, he's not an attorney, so there's legal opinions here. They can't give decisions. He's not an attorney, and they can't be viewed in a vacuum. And if you're going to do this statement, I'd like to suggest what you do, you need to view and put in the entirety of the 5 or 6 hearings, and you take a look at all of that. And I think you can very clear.
Attorney Brown, how is this relevant to, how is Mr. Casiola's opinion in May relevant to whether the ordinance as enacted in November and amended or reintroduced in April in any way relevant to whether or not it's a de facto exclusion?
It's an acknowledgement that a certain setback amount, will it be an exclusionary ordinance, and that business cannot occur. And so it is collaborative and corroborative of the evidence that Range just put on, that certain setbacks that were being considered at that time that were then surpassed in distance by the enacted ordinance would result in a total exclusion of oil and gas business in Cecil Township, which is, as Mr. Casiola recognized, a violation of the law. I would note that Range did not rest its case before I read the transcript.
I do agree with
record.
that, yes. You finished
And
your
it-
witnesses, you did the evidentiary
it-
thing, and so I agree with you on that.
And it is a statement against interest, and the board needs to speak through human beings, just like corporations do.
Can I rebut this? Mr. Volt, may I respond real quickly? Just to repeat something that's already been said. This is in May 2024. I think there's 4 or 5 different versions of this ordinance. There's been 2 different versions of this ordinance just here today. I mean, it's way out of context. It's completely not relevant. Even if you accept that it's not hearsay, which I believe it still is, it's not relevant because it's not talking about the ordinance we're talking about here today. And the full record would reveal it as well.
Mr. Volz,
And just one more point.
We'll go Ms. Moore and
Yeah,
then back to Ms. Brown.
To be clear, I already explained, as the ordinance progressed and changes were made over the course of many, many months, the waiver concept was one concept that was introduced. I would also say that at the time in May, I believe, the board was still considering ordinance overlays, right? So there would be overlay districts. They ultimately got rid of that concept, right? So there is no overlay map. So it's, you're talking about looking at a map and an ordinance at a point in time that is no longer relevant in any way, shape, or form.
again, I will point out, this is not about what specific proposal was under consideration at the time. It is about Mr. Casiola's acknowledgement that certain setbacks of certain distances would result in exclusion of oil and gas development in the township. And he recognized that. He recognized that for a setback that was much lower than the setback that was ultimately adopted in the 2024 and then again in the 2025 ordinance. This is corroborative of Range's testimony from its expert GIS professional that the ordinance excludes oil and gas development in Cecil Township.
On page 5, he referenced you're going to see the maps. Just look at them. Does Range have copies of those maps that he's referring to, showing apparently that 2,500 feet would be exclusionary?
2,500 feet? No, we developed that map, Mr. Goldstone.
No, but Mr. Cassiola writes, it doesn't matter if you would like it to be 2,500 feet. We can't do that. You're going to see the maps. Were those maps ever provided to Range or anywhere else, presumably showing that 2,500 feet would be a complete exclusion?
This is the problem with Mr. Cassiola not being
To
here.
answer your question, Mr. Volz, Range did not get 2,500-foot maps. We did ask, by the way, in a right-to-know request for information. And I would note for the record that the township has not responded fully to that request. That request was made before the ordinance was adopted. And then we made another request recently in March. There were productions for both requests. However, number of documents were withheld from Range. Range is still awaiting those documents. After appeal to the Office of Open Records, the Office of Open Records ordered the township to produce over 100 documents to Range, finding that they were improperly withheld. The township is asking for reconsideration of that ruling, and in the course of asking for reconsideration, agreed that several of those documents, several dozen of those documents should be produced, and yet they still have not produced those documents. And so while Range is willing to close its case based on the evidence that's available to us now, we have not yet received from Cecil Township the information that we requested in a Right-to-Know Act, and we reserve our right, once we do get access to those documents, and they are properly produced to Range, to offer them into evidence in support of its challenge.
First,
Don't have access to those records right now, Mr. Volz, because to the extent they exist, or they still exist, they've been withheld.
Mr. Volz, the Office of Open Records has not yet made a final determination in that matter. Once it does, the township will do whatever the Office of Open Records tells it to do, period. And to the extent Ms. Brown thinks she can just keep this open now because there's some secret map or document, that's absurd. She's put in her case, she's resting tonight. This is an exclusionary challenge. Everything they have, they need, right? Everything they have, they've put on. There's nothing secret that's going to be some magic bullet that's going to show them, prove their case for them. They have the burden to prove their case.
No, I agree with you, Ms. Moore. Range's case has been entered into the evidence. We are going to take a recess. I am going to ask that we take one more executive session before we depart for the evening, if that's all right with the parties. Basically some scheduling issues, and shouldn't be long, but just a few minutes before we set up the other future hearings potentially.
Mr. Volz, to that end, before you do go back in executive session, I don't know if this will make a difference, but on behalf of the township, I was going to and would like the opportunity to make a motion, the equivalent of a motion for a directed verdict, in a sense, dismiss the case, because I don't believe they've met their burden of demonstrating to this board that they have standing, that this case is ripe, that it's not moot, and that should even be considered any further after today.
Okay, we'll discuss that as well when we're back in executive session.
otherwise. Yeah, I mean, it was definitely an order. No, we did.
For Alice Meyer.
Yes. Alice Meichter?
Isn't he
Yeah,
your
yeah.
chairperson?
Pittsburgh, yes.
Huh?
Alice, that was probably the funniest line.
Yeah. I've transitioned.
She was much more
This is
present.
exactly what would be on my head, like, I can't.
We were having a bocce tournament, actually.
Family does bocce.
So, like, oh. Oh, that's fun. Yeah, we were just straight up playing bocce. It's fun. That's fun. Fun sport.
Just give me 1 second. My calendar.
Call meeting back to order, 10:40.
All right, the board met in executive session to discuss how we want to proceed moving forward. One of the issues we've asked the parties to brief is the mootness issue, whether or not the new ordinance obviates this appeal. In addition, since Range has completed its case in chief, we feel that now would be a good time to investigate standing and ripeness and whether or not Range has put forth a sufficient case to demonstrate whether the new ordinance or its newly revised ordinance from 2025 is a de facto exclusion due to the setback requirements. I spoke with council earlier. Due to scheduling conflicts, our May 19th date will not work for certain board members. We were proposing, and this can change, but would like, somewhere towards the week after, 28th, 29th, 30th, and we'll work this out among council and re-advertise. But what we were thinking is that briefs be submitted, proposed findings of fact and conclusions of law be submitted by May 12th, which is 3 weeks from today, and that the board will issue its decision and potentially hear argument on those submissions at its next hearing.
Mr. Baltz, sorry.
I think the timing is challenging, given the fact that we won't have a transcript
Okay.
for tonight's hearing. And that puts Range at a disadvantage with regard to establishing and documenting its findings of fact and conclusions of law. If you want to give us 3 weeks from when we receive a transcript, Range is willing to and able to do that, but I think that it is a challenge to wait for, I don't know, sometimes it's 2 weeks
That's a
to
fair
get a
point.
transcript.
That's a fair point.
Something we can agree on.
Is 3 weeks from the date of the transcript something that works for the parties? We will not have a May 19th hearing, but we will schedule something, do the proper advertising and schedule a hearing, I guess, once we know when the transcripts have been received and when the briefing deadline is set. I've been emailing with council. We have a group email where everybody's on it. Let's continue to use that just so everybody's on the same page. Briefs can be, proposed findings and conclusions can be submitted via that. I think they should be all submitted at the same time, at least on the same day. No replies, just put forth your best cases, and we'll go from there.
The hearing following when you receive the briefing, will that just solely be on arguing the points if necessary on the briefing, or should the township and other interveners be prepared to move forward with evidence?
I think it has to be. I think it would be, we'll have to have a pause so the township can argue and the parties can argue this, and then if we decide to move forward, we won't do it that night. It might not be a month later, right, but it will be not that night.
Thank you.
And with that, I think we are done for the evening. Thank you, everybody. Drive home safely.
Will party status be addressed during that as well?
Thank you. Yes, that is something that should also be addressed. No, I don't, sorry.
We deferred the evidence. If you're going to base it on the evidence of record now, we can do that, but you had deferred evidence on that issue.
So so with respect to, I don't think we need to get into party standing with respect to whether or not they have put forth a prima facie case or whether they have standing to present their appeal. So we'll defer on that issue until later and address it if we need to.
Mr. Volz, are people that have not yet established party standing going to be allowed to argue against Range's standing ripeness and whether or not the issue is moot? Because that would be, in our view, rather unprecedented. We went down this road and the decision was that those issues would be deferred until after the presentation of all evidence because of the deferral of evidence on and the ability for the parties to add additional evidence on their standing as parties.
Frankly, I think under the Bethlehem case, at this point, now that they've all participated, I mean, they're parties for purposes of this hearing. There's a different standard on appeal, of course, but they've been here, they've participated. I think the Bethlehem case says, they're parties, especially for purposes of a legal argument.
Right. I mean, my position is that we'll accept brief from all parties. We will accept argument from the parties. I would hope that the township covers the majority of the oral argument, just because it's their ordinance. To Ms. Moore's point, the standard for getting standing to participate in a zoning hearing board is very low, though Mr. Ferguson might disagree in some cases. But we will we'll proceed under that plan, where we will receive briefs, we will let the parties talk, just like we would let a member of the public share their opinion, especially as far as legal arguments go. So the facts are in the record. I think we can hear argument and receive briefs. So can you let us know when the transcript is ready, and then we'll issue an order from there.
Thank you.
All right.
Motion to adjourn?
Second.
Meeting canceled 10:50.
They all think that was May 19th.
Okay. You know what? We can do that maybe.
Right, because
It'll just be the regular board.